We're outside the presence of the jury. Anything overnight needs to be dealt with by the state,
No, sir, Your Honor.
by the defense.
No, Your Honor.
As soon as they tell me the jury's ready, we'll get started. Y'all have your equipment hooked up?
Yes, sir.
Can I take the course of element for just a second? Give me two for a second.
That's fine. Yeah, we can.
Yeah, you got to go the other way.
All right, I've been informed all the jurors are here.
And Your Honor, can we approach?
Sure. any further? All right, anything from the state? Defense? Bring him in. All right, ladies and gentlemen of the jury, did everyone follow the court's instructions overnight? Did anyone allow themselves, did anyone go do any independent research or allow themselves to be permitted to view any news accounts or social media accounts? Anyone fall in that category? Everyone's shaking their head in the negative. I'm about to give you the jury instructions. I've done this more times than I can count over the last 20, 25 years of my life. Sometimes I hear these instructions in my sleep, but I couldn't sit down and write them all out for you from scratch, I don't believe. You're going to have the instructions to take back with you. So just sit there and listen. You will have the instructions to take back with you to read during your deliberations, okay? All right, members of the jury, you have heard all the testimony and received the evidence in the course of this trial. When you took your places in the courtroom, you made an oath to follow and apply the instructions of the court regarding the law. The court will now instruct you as to the rules of law which you will use and apply to the evidence in deliberating your verdict. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in these instructions by the court. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same in varying ways, no emphasis is intended, and you must not draw. Let's hold down the talk in the audience. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same in varying ways, no emphasis is intended, and you must not draw any inference therefrom. The order in which these instructions are given has no significance as to their relative importance. It is your function to determine the facts in this case and to consider and weigh the evidence for that purpose. You are to apply the law to the facts and in this way decide the case. The evidence which you are to consider consists of the testimony and statements of the witnesses, any stipulations made by the attorneys, and any exhibits admitted into evidence. You are also permitted to draw such reasonable inferences from the evidence as seem justified in the light of your own experience. It is your prerogative to determine what weight and what credibility will be assigned to testimony and supporting evidence of each witness in this case. You are required and expected to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who has testified. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. The production of evidence in court is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourselves with the reasons for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any ruling by the court on these motions or objections to the evidence that the court or the judge has any opinion on the merits favoring one side or the other. You should not speculate as to possible answers to questions which the court did not require to be answered. Further, you should not draw any inference from the content of these questions. You are to disregard all evidence which was excluded by the court from consideration during the course of the trial. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty of every material element of the crime with which she is charged. Before you can return a verdict of guilty, the state must prove that the defendant is guilty beyond a reasonable doubt. The defendant is not required to prove her innocence. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree thereto. In other words, all 12 jurors must agree on any verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberation, do not hesitate to re-examine your own views and change your opinion if convinced that it is erroneous, but do not surrender your honest convictions as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The court instructs the jury that the defendant has a constitutional right not to testify at trial. You should not draw any inference from the defendant's failure to testify. The defendant's failure to testify should not in any way be considered by you during the course of your deliberations. The court instructs the jury that you have heard testimony from expert witnesses. Persons who by education and experience have become an expert in some field may state their opinion on matters in that field and may also state their reasons for the opinion. Expert opinion testimony should be judged just like any other testimony. You may accept it or reject it, and you may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all other evidence in this case. You are instructed that the indictment creates no inference of guilt, and the fact that the defendant was indicted shall not be considered as evidence against him by the jury, and no inference of guilt can be drawn therefrom. You must not base your verdict solely on the number of witnesses for either party. The defendant, Carly Madison Gregg, has been charged by indictment in count 1 with the crime of first-degree murder, in count 2 with the crime of attempted murder, and in count 3 with the crime of tampering with physical evidence. Count 1. The court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of first-degree murder. You find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, feloniously, and without authority of law kill and murder Ashley Smiley, a human being. With deliberate design to effect the death of Ashley Smiley, then you shall find the defendant guilty as charged in count 1. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 1 of the indictment. The court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of attempted murder. If you find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, unlawfully, and feloniously attempt to kill Heath Smiley, a human being, but failed to complete the act, then you shall find the defendant guilty as charged in count 2. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 2 of the indictment. Count 3, the court instructs the jury that the defendant, Carly Madison Gregg, has been charged in the indictment with the crime of tampering with physical evidence. If you find from the evidence in this case beyond a reasonable doubt that on about the 19th day of March 2024 in Rankin County, Mississippi, the defendant, Carly Madison Gregg, did willfully, unlawfully, and feloniously intentionally destroy, mutilate, conceal, remove, or alter physical evidence with intent to impair its use, verity, or availability in the pending criminal investigation or prospective official proceeding, then you shall find the defendant guilty as charged in count 3. If the state has failed to prove any one or more of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty as charged in count 3 of the indictment. The court instructs the jury that there is a presumption that an accused is sane, and therefore the burden is initially on the accused to introduce evidence which creates a reasonable doubt as to her sanity at the time of the act. However, once the defendant has created a reasonable doubt as to the defendant's sanity, it is the burden of the state to present sufficient evidence to prove the defendant's sanity beyond a reasonable doubt. The court instructs the jury that the following is the definition of insanity in Mississippi. Insanity exists when at the time of committing the act, the accused was laboring under such defect of reason from disease of mind as 1, to not know the nature and quality of the act she was doing, or 2, if she did know the nature and quality of the act, she did not know that what she was doing was wrong. The court instructs the jury that if you find that the state has proved beyond a reasonable doubt all the essential elements Count 1, first-degree murder, Count 2, attempted murder, and Count 3, tampering with physical evidence, then you must find the defendant guilty of Count 1, first-degree murder, Count 2, attempted murder, and Count 3, tampering with physical evidence, unless the state of Mississippi has failed to prove beyond a reasonable doubt that the defendant was sane at the time the defendant committed the crimes of Count 1, first-degree murder, Count 2, attempted murder, and Count 3, tampering with physical evidence. In order to prove the defendant sane at the commission of the crimes of Count 1, first-degree murder, Count 2, attempted murder, and Count 3, tampering with physical evidence, the state must prove beyond a reasonable doubt that at the time of the commission of the crimes of Count 1, first-degree murder, Count 2, attempted murder, and Count 3, tampering with physical evidence, the defendant had the mental capacity to realize and appreciate the nature and quality of her acts and to distinguish between right and wrong with reference to the act she committed. If after considering all of the evidence in this case you find that the state has failed to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the crimes in Count 1, first-degree murder, Count 2, attempted murder, and Count 3, tampering with physical evidence, then your verdict must be not guilty by reason of insanity. The court instructs the jury that if you find that the defendant, when sober, is capable of distinguishing between right and wrong, and the defendant voluntarily deprives herself of the ability to distinguish between right and wrong by reason of becoming intoxicated and commits an offense while in that condition, she is criminally responsible for such acts. The court instructs the jury that when all 12 of you reach and agree upon a verdict as to the indictment, you shall return the verdict to the court in one of the following forms. Count 1. Should you find the defendant guilty of first-degree murder as charged in the indictment, then state your verdict as follows. Quote, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Close quotes. Should you find the defendant not guilty by reason of insanity, then state your verdict in one of the following forms. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that the defendant has since been restored to reason. Close quote. R. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that she has not been restored to her reason and is a danger to the community. Close quotes. Should you find the defendant not guilty of first-degree murder, then state your verdict as follows. Quote, we, the jury, find the defendant not guilty of first-degree murder. Close quotes. Count 2. Should you find the defendant guilty of attempted murder as charged in the indictment, then state your verdict as follows. Quote, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Close quotes. Should you find the defendant not guilty by reason of insanity, then state your verdict in one of the following forms. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that the defendant has since been restored to reason. Close quotes. R. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that she has not been restored to her reason and is a danger to the community. Close quotes. Should you find the defendant not guilty of attempted murder, then state your verdict as follows. Quote, we, the jury, find the defendant not guilty of attempted murder. Count 3. Should you find the defendant guilty of tampering with evidence as charged in the indictment, state your verdict as follows. Quote, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Close quotes. Should you find the defendant not guilty by reason of insanity, then state your verdict in one of the following forms. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that the defendant has since been restored to reason. Close quotes. R. Quote, we, the jury, find the defendant, Carly Madison Gregg, not guilty by reason of insanity, and we find that she has not been restored to her reason and is a danger to the community. Close quotes. Should you find the defendant not guilty of tampering with evidence, then state your verdict as follows. Quote, we, the jury, find the defendant not guilty of tampering with evidence. Close quotes. Write your verdicts on a clean, separate sheet of paper. It is not necessary that you sign the verdicts. Counsel for both sides will now have an opportunity to address you and make their closing or final arguments. The arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but they are not evidence. The attorneys in making these arguments to you will be commenting upon the testimony that you have heard and the evidence that has been presented in this case. They, as you, will be recalling the evidence that has been presented. They should not intentionally try to mislead you. However, if their recollection of the evidence differs from what your recollection is, you must follow your own recollection. If any argument, statement, or remark has no basis in the evidence, then you should disregard that argument, statement, or remark. Jury instructions will be on the bench in front of the court. If either side needs them, you can come get them. If you use them, return them in the same order you picked them up in. Closing arguments on behalf of the state. Mr. Shipley, you'll keep time?
May it please the court. Good morning, ladies and gentlemen. As Ms. Todd stood before you on Monday in her opening statement and told you this is not a case about who did it. And in fact, all of the evidence that you've seen tells you exactly that. It's not a case about who did it. You haven't seen one shred of evidence in this case that what happened on March 19, 2024 was caused by anyone other than Carly Madison Gregg. The defense also told you during opening statements on Monday that the state wants you to leave your common sense at the door. That they want you to tie it up in a bucket and leave it at the door. Ladies and gentlemen, all we want you to do in this case is use your common sense. And in fact, that's what Judge Arthur just instructed you to do in the very first jury instruction. And I want to talk about a few of these jury instructions with you real quick. But in jury instruction number 1, which you'll have back in the room with you, on the second page, he instructs you, you're required and expected to use your good common sense and sound, honest judgment in considering and weighing the testimony of each witness who has testified. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. Ladies and gentlemen, on behalf of the state, all we want you to do is to go back there and use your good common sense and your sound, honest judgment. And again, I don't believe that you've heard one shred of evidence throughout this entire week that the person who shot Ashley Smiley was in fact Carly Madison Gregg. The person who shot and attempted to kill Heath Smiley was Carly Madison Gregg. And the person who took down the camera from the kitchen and hid it in the refrigerator behind some water bottles was Carly Madison Gregg. Now, Judge Arthur also read you the elements of the crimes. And again, you'll have this information back there with you in the jury instructions. It's jury instruction number 8. And I kind of want to go down because as a simple person myself, I like to kind of have a roadmap as to where I'm going. So I like to be able to look at things and see them on paper, and that's exactly what these jury instructions provide you, kind of a roadmap to help guide you in your deliberations. So I want to talk about count 1, which is the first-degree murder. And there's 3 elements here that it has listed. And the very first one says that on about the 19th day of March, 2024 in Rankin County, Mississippi. That's the first thing you have to find. Ladies and gentlemen, all the testimony has been that this happened on March 19th, 2024. You heard from Deputy Hunter Lewis, who was the first deputy who arrived on the scene there, that he was called out that day, that he received a call from dispatch to respond to 214 Ashton Way, which is in the Farmington Station subdivision off of Old Fannin Road. And you heard Mr. Kevin Collins, the 911 dispatcher, who told you that the call out came on that day at that time about 5 o'clock in the afternoon. And you heard them tell you that obviously Farmington Station is located in Rankin County, Mississippi. So there's no question as to that first part of the element there. As to number 2, that the defendant Carly Madison Gregg did willfully, feloniously, and without authority of law kill and murder Ashley Smiley, a human being. Well, ladies and gentlemen, you heard from Mr. Cliff Dunlap, the deputy coroner, who told you that the manner and cause of death in this case was found to be 3 gunshot wounds to the head, and that it was found to be homicide, and that the victim was indeed identified as Miss Ashley Smiley. The last part there is that she did it with deliberate design to affect the death of Ashley Smiley, the victim. Ladies and gentlemen, I would submit to you that in the state of Mississippi, when it talks about deliberate design, that it's simply talking about an intent to kill. An intent to kill the victim, Ashley Smiley, that she did this with an intent to kill. And I would further submit to you that the use of a deadly weapon is an intent to kill. Whenever you aim a deadly weapon, a pistol, a .357 revolver, at someone's head and you shoot 3 times, that's certainly an intent to kill. Now, again, it's not a case about who did it. And I'll show you some of the video here in just a second. But let's think about what happened that day. So you remember from the video, you saw from the garage, you heard several witnesses talk about it, that earlier that day, Mr. Bennett Germany and another friend, Sarah Catherine Rayleigh, who the defense put on the stand yesterday, you heard from them, and they said they devised this plan to go talk to Ashley, to go talk to Carly's mom, because they were worried about Carly. They were good friends. They were worried about Carly, and they were worried about her drug use, her use of burner phones. And I just want to be clear, ladies and gentlemen, this is not a case about marijuana and whether or not she was smoking marijuana. This is a case about whether or not she was intoxicated, voluntary intoxicated. You heard me talk to Dr. Clark about that she would, one of these times that she says she has one of these events where she supposedly zoned out. That, in fact, what happened was that she went and smoked marijuana. It could have been any drug, but it was just marijuana. And she zoned out, and she had this event where supposedly she says that she, fell out on the floor and whatever happened. And she did that after her mom and Heath left one day and went to the grocery store. But I just want to be clear, it's not a case about marijuana. It's simply a case about, her actions. And so Bennett and Sarah Catherine, they devised this plan. They're going to tell Miss Smiley. Well, obviously, you heard testimony that one of the things that Miss Smiley was worried about was her daughter, Carly, the love of her life. You heard that she had another daughter who died at a very young age from some type of genetic disorder that she had. So you got Carly here. She's the love of Ashley's life. Obviously, she's disappointed, probably a little bit sad, probably worried for her daughter. And the last thing that she wants her to do, according to the defense, is turn into her dad, right? Her biological dad, who you've heard about, who obviously liked to use a lot of drugs, abuse a lot of drugs. So at some point, she confronts Carly. She searches her backpack, whether in the car, on the ride home, or at school. And then you see them get home, and you heard Dr. Pickett talk about it yesterday, that the situation seemed a little bit tense, right? That they get out of the car in their garage. You don't hear, they're not talking to each other. And they go in. You see Ashley put her coat and her phone down on the bar there in the kitchen, and she proceeds directly to the side of the house where Carly's room is located, presumably to start searching through Carly's room, right? And so you see Carly kind of walk back and forth. You see her walk there to the living room area and kind of listen to see what her mom's doing. At some point, she eventually takes the dogs out, right? I don't know what happened while she was outside, ladies and gentlemen, but at some point, whenever she was outside, she made up her mind, if not long before. We'll talk about that in a second, her conversations with her friend from MSMS, Thad, that you heard from. But at some point outside, she makes up her mind exactly what she's going to do. And she comes back in from taking out the dogs. She walks there to that living room area, kind of listens to see if her mom's still in her room. And then, without hesitation, she walks, as Dr. Pickett said, to the side of the house, her mom and Heath's bedroom, where this pistol is located. She knows it's located there. Now, they want you to believe that from the time she brought the dogs back in, or took the dogs out, that she blacked out at that point. You heard me ask Dr. Clark. Well, from the time she took out the dogs to the time she was arrested by Deputy Shack, who you also heard from, that she was blacked out in that period. Well, that's a real convenient time to be blacked out, right? And so she brings the dogs back in, and she goes directly to her mom's room and Heath's room, and she retrieves this pistol. And you see her walk back across the screen. Well, when she gets there, she looks around the corner into the kitchen to make sure that her mom hasn't come out of her room, knowing exactly what she's doing. Cool, calm, calculated, and callous. She walks directly. She proceeds to her room, and a couple seconds later, you hear the shots. Boom, boom. You hear 2 shots within 3 seconds of each other. You've seen the pictures. You heard Dr. Pickett testify yesterday. 2 well-placed shots right to the side of Miss Smiley's head, a relatively small target. And then a couple seconds later, boom, you hear a 3rd shot right under the chin. And we believe it's right under the chin is the 3rd shot. We know it's right under the chin. We believe it's the 3rd shot. You heard Deputy Investigator Burnell talk about the stippling, the powder burn around the shot, right? And he tells you that based off his training and experience that shot had to be within 36 inches because that's when you see stippling. The powder that comes out that's still ignited, that doesn't have time to burn, and it burns right here on Miss Smiley's face. And then what does she do? Immediately. You'll see on the video that happens at 4:14 p.m. Immediately she comes back in. She gets on her mom's phone. She has the wherewithal to enter her mom's code onto her phone and to text someone specific. And that someone specific was her stepdad, Heath Smiley. And you'll see that text message was sent within the same minute, 4:14, that she shot and killed her mom. And what does she say to him? Something to the effect of, "When are you going to be home, honey?" And it's perfect grammar. The comma's in the right place right before honey, right? She knows exactly what she's doing. She comes in there. She knows exactly where the camera is. She comes. She's got the gun hidden behind her. She slides down into the chair, and you hear her put it down on the bar stool. You can hear it whenever you get back to the jury room. You'll be able to hear that. She puts it down. You hear Dr. Pickett talk about it. She's got the wherewithal to know exactly where the dogs are. The dog walks behind her. You'll see it. He walks behind her, and she knows let me make sure he doesn't knock the gun off. Right? At some point, she begins text messaging her friend. She shoots her mom at 4:14. Then she invites her friend from school, who you heard from, Brooke. She invites Brooke over. You'll see the messages between her and Brooke. They're in evidence. And you'll see where Brooke texts her at 4:58, basically 45 minutes later, and says, "I'm here." Brooke had no clue what she was about to walk into. Carly meets her at the door, says something to the effect of, "Have you ever seen or are you squeamish of dead bodies?" Well, Brooke says, "I don't know. I've never seen a dead body." Not thinking that there's a dead body currently in the house. Right? Carly's walking around with the gun. Carly leads her back to the room and shows her dead mom, who's got her arms crossed over, who's been posed. Right? She's posed her mom at this point. She's put her arms across her. She's put a red towel over her face. Again, cool, calm, and calculated. She knew exactly what she was doing. She knew exactly who to reach out to during this time. She's reaching out to all of her friends. You heard from multiple friends that she reached out to. You heard from her friend Thad, who she was texting. And actually, before they text, she calls him on FaceTime. And what does she tell him? Well, she tells him, and excuse my language, "I fucked up." Right? Well, how do you know you messed up if you don't know what you did? She knew what she did. She knew the difference between right and wrong. So she obviously tells Thad, but she can't tell him what she did. She knows she can't tell him over the phone. Well, then, being a good friend and being worried, Thad begins to text her after they get off the phone. And they're messaging. Well, of course, in the meantime, she's walking back and forth in and out of her room where her mom's located. She's walking back and forth. She's sending messages to multiple other friends. And Dad is messaging her, but he can't get a response. And he says, "I'm worried about you. If I don't hear from you, I'm going to call 911. And she says, "You can't do that." Why? Why can't you call 911? Because she knows what she did was wrong. and she doesn't want 911 over there because she's about to try to kill Heath. And she doesn't want 911 over there because it's going to ruin her plan. Right? Knowing the difference between right and wrong. And you heard me, I very specifically asked Dr. Clark, you render the opinion that she could not appreciate the difference between right and wrong. Right? Well, you heard Dr. Pickett and Dr. Gugliano testify yesterday. That's not the standard in Mississippi. In fact, there's an instruction in here that defines, it's jury instruction number 10, that defines exactly what insanity is. And it goes on down there, and it says that the accused was laboring under such defective reasoning from disease of mind as to not know the nature and quality of the act she was doing, or two, if she did know the nature and quality of the act she was doing, she did not know what she was doing was wrong. It's not appreciate. The standard in Mississippi is not that you appreciate the difference between right and wrong. She knew what she was doing was wrong. Look at all of her actions. Sneaking around the house. Calling over the friends. Knowing not to tell the friends over the phone what she did. SK that they called in yesterday, her friend. You know, what does she say? Dr. Pickett talked about it. Well, she says, I'll tell you tomorrow if I see you. Well, why would I not see you tomorrow? Well, because I'm going to be in jail, probably. Right? She knew what she did was wrong. She tells her friend, Brooke, whenever Brooke comes over, she says, I put 3 in my mom, and I've got 3 more in here for Heath whenever he gets home. Right? I'm going to take care of him. 3 more what? 3 more bullets in the gun. She texted her friend, Bennett, tried to call him, did call him, text him, and he tells her, of course, again, he's a good friend too. He's worried about her. Same one that told her mom what had been going on, that he was worried about her. Trying to do the right thing. He tells her, don't hurt yourself or anyone else. Don't harm yourself or anyone else. What does she say? Too late. Again, knowing the difference between right and wrong. You saw the video from Deputy Shack, and they want you to believe that he did something wrong because he muted his body cam or whatever he did. He told you that whenever he got Carly out of the back of his car and the other deputy started performing the GSR test on Carly's hands, which you saw them doing there, being as nice as all get out to her, right? Baby, are you okay? You heard him say that his involvement in the case was over. He never went in the house. He didn't transport her to jail or anywhere else.
2 minutes, sir.
They want you to believe that him muting the body cam was him doing something wrong. He told you that his involvement was done and over at that time. Now, I want to play just a short clip of the video for you before my time's up. ladies and gentlemen, there's no doubt that Carly Madison Gregg is the one who killed her mom, Ashley Smiley. There's no doubt that she attempted to kill Heath Smiley when she aimed the gun right at his head and shot and hit him in the shoulder. And there's no doubt that she's the one who hid the camera, thus tampering with evidence in the refrigerator. And we would ask you that you go back there and you find her guilty of all three, because she was not insane at the time that this happened. She knew exactly what she was doing, and she knew the difference between right and wrong.
Minute and a half on the back end, so it'll be 18 and a half minutes for second close. All right, closing by the defense.
May we begin?
Yes, ma'am.
Good morning. I know it's been a long week for all of you guys, and I know you're tired of coming here every day, but I want to take a minute and talk about why the state has the burden of proof that they have, the highest burden of proof that our law allows, which is beyond a reasonable doubt. A lot of people think that having that high of a burden is there because it's supposed to protect the defendants in criminal cases. But in fact, I think it protects the jurors just the same, if not more, than it does the defendant, because making the state prove every element of their case beyond a reasonable doubt is what is going to keep each of you from waking up in the middle of the night. The decisions that you make today will not just affect Carly Gregg, it will affect her entire family. And it's a heavy burden to carry. So I want to take a few minutes and talk about the truth. The truth is rarely pure and never simple. That's what Oscar Wilde said. Let's talk about what is undisputed in this case. It is undisputed that Carly loved her mom. You never heard the testimony of one person in this case who said otherwise. It's undisputed that Carly had no history of violence prior to March 19th. Nothing you heard. There is no evidence that tells you otherwise. It's undisputed that Carly Gregg loved her stepdad. In fact, he was the only dad she really ever had. No one told you otherwise. It's undisputed that Carly Gregg believed her father had a mental illness, bipolar disorder and schizophrenia. Carly was afraid of her dad. She knew he was an unsuccessful man. She knew he was abusive. She didn't like being around him. She didn't want to be like him. It's also undisputed that that's something Carly worried about all the time, because that's something her mom worried about all the time. Her mom frequently worried that Carly was going to end up with the same mental illnesses that her dad had, because they're hereditary. It is undisputed that Carly had been experiencing serious mental health issues for quite some time prior to the events of March 19th. She had bulimia for 2 years. She had intrusive thoughts. She had racing thoughts. She had engaged in self-harm behaviors. Carly had anxiety. She had been diagnosed with a major depressive disorder, and she had developed trouble sleeping for months prior to March 19th. Moreover, we have her journal entry from April 7th of 2023 in which she writes down, "Do I have schizophrenia?" We have Carly's other journal entries prior to March 19th, including her journal entry on March 12th, which you'll have back there in there with you, and I implore you to read, in which Carly writes down and says, "Am I having a psychotic break?" Talking about the voices in her head. we heard the testimony of SK, and that testimony came out on cross-examination, not with me on direct, but with the prosecutor on cross, that yes, Carly did in fact tell somebody prior to March 19th that she'd been hearing voices in her head. And who did she tell? The person she was most likely to tell, her very best friend, who told us that they told each other everything. Now, it is also undisputed that Carly's mental health issues worsened by December of 2023 to the point that her parents sought medical intervention and put her in counseling and got her on an antidepressant. And I want to take a minute and break that decision down, because we've spent a lot of time in this case talking about Carly and her mom and how much they loved each other. But I want to break down the decision a mom is making to put her child on an antidepressant at that point. What did we know about Ashley Smiley? That she was an incredibly loving mother. Her world revolved around Carly. What Michael just told you was true. Carly was the love of her mother's life. We also know that Carly's mom was overprotective, and understandably so, because she had lost a child. Carly was the only child she had left. Do you honestly believe that loving, overprotective mother would make a decision to put her child on an antidepressant medication when she herself had had horrible side effects when placed on Prozac? She'd become suicidal. Do you think that mother would have taken any risk with her child, the only child she had left, knowing how serious those risks were, when she decided to put her 14-year-old on an antidepressant medication? No, of course she wouldn't. That tells you everything you need to know about the serious issues Carly was having, whether her parents wanted to admit it, whether Carly wanted to admit it or not. You can't tell me Ashley Smiley, as loving and protective as she was, would have taken that risk with Carly if it wasn't required. Now, knowing all this, it's also undisputed by Rebecca Kirk, the only medical professional who spent more than a day with Carly that you heard from in this case, who had treated Carly from January of 2024 to March of 2024, a 3-month period of time, that Carly was a sweet, gifted child with no history of violence. Ms. Kirk also called the taking the knife to school incident much ado about nothing. She told us that it was evident that Carly loved her mom, wanted to please her mom, and was worried about stressing her mom out, to the point that Carly walked on eggshells, trying not to upset her mom. She told us a story about how at one point Carly saw her mom having to grade a bunch of tests, being stressed out, and Carly wanted to help. So she asked her mom if she could help her grade the test. And when Ashley snapped back, which is something parents sometimes do when they're stressed out and a child catches you at the wrong moment, that hurt Carly's feelings so much, that was the only thing that Rebecca Kirk could pull out of her when she was trying to get Carly to open up about traumatic experiences she had had. Just having a mom snap at you was traumatic to Carly. How could Carly tell her mom she was experiencing the same mental health issues that her dad had? How could any 14-year-old? It's also undisputed from Ms. Kirk herself that she knew there was more going on with Carly than Carly was disclosing. And she worked very hard at that last session trying to pull it out of Carly, to the point that she thought, maybe I should refer them to somebody else, because there's more here than I can get to. We've heard the testimony of Carly's stepfather, who has no reason to defend this child. It's not his biological child. He was very much in love with his wife. They were still in the honeymoon phase. You heard him on that 911 call. That was a man in shock, in grief, and in pain. You heard his testimony about feeling intimidated regarding his testimony in this case. But despite all of that, he has continued to tell the truth consistently from March 19th until his testimony in this courtroom today, and he continues to stand by Carly to this day and support her. And he said, yeah, I've noticed that Carly was experiencing memory lapses in the fall of 2023. It was bizarre. I noticed that Carly was losing track of time. It was bizarre. They knew Carly wasn't able to sleep. They were worried about how much melatonin she was taking to try to sleep at night. We heard from Dr. Pickett how that all correlates with bipolar disorder. It is undisputed from the testimony of the minors who testified in this courtroom today, this week, that Carly had only started smoking marijuana in February. It is also undisputed by the testimony in this case and the records we put in evidence from BioCorps, which you'll have back there with you, and I hope you'll look at, that it was only after Carly was finally put on Abilify, an antipsychotic medication, that the voices stopped and her mental health issues decreased. The crying spells, the depression, the low lows. Only after the antipsychotic medication. And why? Well, we heard from the medical professionals why. In the words of Dr. Clark, when you have a child experiencing psychotic issues, you have to stabilize their mood before an antidepressant can be effective. And if you don't stabilize their mood, then the antidepressant can do more harm than good. And that's exactly what happened to Carly Gregg on March 19th. We heard the video from the garage cam of Heath Smiley coming home on March 19th. We heard those feral screams that Carly made the whole time. And we heard the testimony of Mr. Smiley that he was so convinced by the state of terror Carly was in that after she left that house and he was wounded and bleeding, he walked around the house with the handgun looking for the intruder that he believed was there based on the state of terror Carly was in. We heard the screams. You can't fake that. You can't make that terror up. Carly has consistently reported to everyone that the last thing she remembered on March 19th was taking the dogs out, and the next thing she remembered was crawling through a sewer filled with water. And I personally believe that it was the cold water that brought Carly back out of it and back to herself, the shock of it. The state would have you believe that Carly intended to kill her mom on March 19th when Carly didn't even know during the evaluations that her friends had sought to intervene because they believed that what they saw from Carly was due to marijuana use that started in February rather than symptoms of a mental illness that they could not know about. But that story just doesn't track. Because for the genius kid that Carly has been repeatedly described as, don't you think she would have known if she intended to do what she did on March 19th, where the camera was in the kitchen, and that she ought to take it down before it films her doing everything she did? Because I didn't make a 30 on my ACT, but I would have known to do that. That doesn't sound like the actions of a smart kid who was intending to do anything. If Carly intended to kill her mom because her mom found out she was smoking pot, then why wouldn't she have left the house after she killed her mom? Why not run then? Why call all of her good friends asking for help, terrified, crying, saying she couldn't tell them what happened? Why text her stepdad anything? Why wait in the house? And what did her stepdad have to do with anything? He didn't know about the marijuana usage. He didn't have any skin in that game. It doesn't make sense. And the state can't tell you why she did any of those things. But they have to prove it to you beyond a reasonable doubt. Now, no one not her stepdad, not her counselors, not Dr. Clark, who was teaching psychiatry at Harvard while Dr. Pickett was still in medical school, believed that Carly was a sociopath or a psychopath. Even Dr. Pickett said that was going too far. The state put on the testimony of BW, who is the only person who told us anything about Carly making a statement about shooting her mom, and she had 3 more for her stepdad. I didn't hear that statement from the law enforcement officers that interviewed her. I heard it from the prosecutor. But I also heard from the prosecutor that BW was a little bit of an unreliable witness because she answered the first question of, where did Carly get marijuana from? I don't know. To have to answer immediately with the follow-up question, well, isn't it true that you bought it and gave it to her? Yeah, that's true. So that tells us right there, we've got a little bit of an unreliable witness. Now, we also had Dr. Pickett, who gave us his opinion. But Dr. Pickett admitted that he had no experience whatsoever in the field of child and adolescent psychiatry. He had never evaluated a child before Carly. He had never testified in a criminal case before, and he had never qualified as an expert before in anything, in any criminal case before this one. So I have a hard time accepting Dr. Pickett's opinion that, especially when he is discounting the diagnosis of a doctor who diagnosed Carly's father with bipolar disorder, and the reason that Dr. Pickett told us that he discounted this other doctor's diagnosis was because that doctor had only seen Kevin Gregg 3 times. Well, Dr. Pickett saw him 0 times, but yet he's able to undiagnose him and re-diagnose him? I mean, if Dr. Pickett can diagnose or undiagnose someone without ever seeing them, he's going to have a hell of a career. And even though Dr. Pickett denied having a preconceived bias going into this case, I couldn't help but realize he had memorized all the medication that Kevin Gregg was on that he believed contributed to Kevin Gregg just being a drug addict. But he somehow missed the 3 antipsychotic medications that Kevin Gregg had been on. That Mr. Gregg had been prescribed for his bipolar disorder and possibly schizophrenia. But you know what? Those facts didn't fit his story, so no need to include them. And I actually couldn't stop thinking about that. Why was it that he memorized the medications he believed were easy for people to abuse and become addicted to, but just couldn't remember it all? The 3 antipsychotic medications that Mr. Gregg was on at the same time. That stood out to me, who's not a doctor and who doesn't have training in this field. I had to go Google those drugs to learn they were antipsychotics. And then I realized when I was looking at Dr. Pickett's CV, which we also put into evidence, and I hope you look at, that he served as a Hinds County Sheriff's deputy for 3 years prior to going to medical school, and it made sense. Dennis' diagnosis made sense to me, because when you're a hammer, everything looks like a nail.
2 minutes, ma'am.
Thank you. I hope that seeing all the people who knew and loved Carly the best prior to March 19th, her friends, her maternal grandparents, her stepfather, her counselor, I hope seeing that they still love and support Carly Gregg after March 19th tells you everything you need to know about the incident that occurred on March 19th, that wasn't Carly. Because if it was, why would the parents of those friends still let their daughter call Carly? Why would they be here testifying for her? And let's talk about this genius kid. The easiest story she could have told would have been, I shot my mom and stepdad because my stepdad had been molesting me for years. My mom knew about it and said nothing. And people would have bought it all day long. That's a convenient lie. And it would have served her all day long at the expense of her mom and her stepdad. That's the easier story to tell. But that's not what Carly said. Carly told the hard truth about her mental health issues. A truth that these are rare and it's happening, but that this happens often when you put kids on the wrong medication, when they already have these underlying significant mental health disorders and they get treated with the wrong medication. This is what can happen. I hope none of us are ever judged by the worst moments of our life, but rather by our lives as a whole. And I think when you step back and you look at the facts of this case as a whole,
Any further time will be deducted on the
Okay.
back end.
and when you look at the facts of this case as a whole, and the picture of who Carly Gregg is as a person on a whole, you will see that this was not a bad kid. This was not a kid who was enraged. This was not a kid who had hatred in her heart for her mother or her stepfather. In fact, the exact opposite. This was a kid who was experiencing significant mental health issues, the same mental health issues that ran in her family and that we know are hereditary. This is the kid who was compliant with the medication she was put on. However, that medication, without anyone being able to tell beforehand, caused her symptoms to worsen. And while she was having a state of psychosis, in an episode of acute stress on March 19th, she lost herself in what was the perfect storm. I am asking you, for those reasons, to please find Carly Gregg not guilty by reason of insanity and finally quell this storm for Carly and her family. No one will understand this case and no one has heard this case the way that you have. And passing judgment on another person is a heavy burden to bear, and I'm sorry that it falls on you. But please consider what is at stake in this case for this child and this family before you rush to judgment and render your verdict. Look at those documents. Consider the testimony. Search your heart for what you know about this child from the what was the intent? You tell me why someone who intended and had planned to murder someone wouldn't have taken the camera she knew was in the kitchen and was easy to see down before she did anything, especially when she was a genius. I mean, that's not the actions of a diabolical evil genius, leaving camera footage up for everyone to see, crawling through a sewer instead of just running away, calling friends for help, friends who could later testify about what happened. Again, I ask you to search your hearts and remember the undisputed truths in this case. Thank you.
Mr. Camp, 17 minutes.
Thank you, Your Honor.
We'll start the clock until you have everything set up and you're ready then.
I'm good, Your Honor. May it please the court?
Yes.
Okay, we've been doing this since Monday, so I know y'all are probably as tired as I am. This was always going to be a very difficult case, and it's going to be difficult because the issues that we're dealing with is difficult. uh, because we're in we're in part of a realm of the law and everything where you've been hearing a case all week, and the defendant has basically said she's guilty. And so there's not an issue of guilt in this case. As we said from the get-go, this is not a who did it case. This is why it happened. Okay, what's going on? That's what you have to make the determinations is what's going on in Carly's mind as all this stuff is happening. And that's the difficult part, because you don't get to just look at the video and say, she did it, because most cases that's what you're doing. And it's an easy decision, because you're looking at it and you simply see who did what, how they did it, and that's it. Now, in this case, because we're dealing with her mental state, we're having to get inside her mind and understand what's going on and how that's all working. And that's what this case has always been about from the get-go. It's never been about who did it. One of the things that I wanted to talk with you just a little bit about is you had, in this case, one of the things that I wanted to talk with you just a little bit about is you had, in this case, you had three psychiatrists, or excuse me, one psychologist, two psychiatrists. And both of the psychiatrists were forensic psychiatrists. The psychologist was a forensic psychologist. And you had the two psychiatrists gave very different opinions. Very different opinions. And some of the things that I wanted to point out on that is you have one of the doctors, which is Dr. Pickett. It was his first time ever being qualified as an expert. First time testifying. He just got certified a year ago. And then you have an opinion of somebody who has even a higher degree, and that's Dr. Clark. And Dr. Clark is board certified in pediatric and adolescent psychiatry, which means he deals with kids. He deals with teenagers. He knows the nuances of how that works. If you listen to Dr. Pickett, and Dr. Pickett was 100% correct on this, he can do evaluations on everybody. But the problem is, he doesn't know the nuances of the kids and the adolescents. And we're dealing with an adolescent. Carla was 14 when this happened. She turned 15 in jail. As all of y'all know, things are changing in people's bodies at those ages. They're growing, they're becoming adults. You have a lot of different things going on. All those things have to be taken into consideration when you're coming up with the decisions, or when you're coming up with how to do an evaluation on a person. And that's why you need that specialized knowledge, is to know what's going on in teenagers. Dr. Clark gave you a very precise reason of how all this happened, why it happened. And he said it was a difficult case to look at. Dr. Pickett, he basically wanted to just pick Dr. Clark's case or diagnosis part and say, couldn't happen. And one of the big issues with that was the diagnosis of Carly's father. And why that's important is one of the prongs, and I know you've heard psychiatric stuff all week and it sort of gets old, but one of the prongs in order to see if somebody, I guess, is bipolar, one of the big issues is has that person, or does that person have a family history? And that's why that became a big issue. You heard Dr. Pickett get up there, and he looked at Dr. Hardy's stuff and said, well, I'm going to change the diagnosis. So he said, I'm going to discount that, which takes one of the prongs away with one of the things you're looking at with Carly. The other stuff that he wanted to discount, and I thought this was interesting, is you're reminded about SJ, or SK, when she got up on the stand, and she said, yeah, Carly had been hearing voices. I knew about it. Carly said that. Dr. Pickett, you heard him on the stand. It's like, if you bring me credible evidence, you bring me something, and I'll change my mind. But you had the friends say, oh yeah, I mean, we talked about it. Comes out on cross-examination, not direct, which was interesting. But it comes out, and then Dr. Pickett sits there and says, well, it's a friend, so I'm not going to count that. Okay, there's a journal. Okay. In the journal, Carly makes some notes about that she's heard voices and stuff. I'm going to discount that because I think that's her embellishing. All this stuff is, all the SJ's testimony, the journal, all that stuff's happened before this situation took place on the 19th of March. And it's important because what you're seeing, and it's what Dr. Clark said, there's probably an undiagnosed, or there was an undiagnosed situation going on. It happens for a lot of different reasons. You have an individual, Carly, who's not telling everything. We know that. We know a lot more now than we did before. You heard from Miss Kirk, and I thought Miss Kirk was one of the things that was very enlightening with what Miss Kirk said. She was having a difficult time getting anything out of Carly. She really wasn't opening up. So finally, the last session, which happens to be right before this happens, she was able to open up a little bit with her and get some more information. And in Carly's journal, there's an entry in there that talks about she likes Miss Kirk and that she may bring her the journal and let her see some of the stuff. That was something that was interesting. The other part that Miss Kirk said, she had no idea. Nobody had any ideas that this was going to happen. That there was a chance that this could happen. There were no clues. There was nothing. This is one thing I do agree 100% with Dr. Pickett on. And he said this was an unusual case. And the reason why it's such an unusual case, daughters don't go and shoot their mothers for no reason. Dr. Clark talked to you a little bit about it. It's like, well, usually you either have panic, and we saw it from the video and everything. There's no panic. He also talked to you about that there was mental issues that were going on. They had started in January. She was getting treatment. We didn't know how bad they were, but she had started getting treatment. They were getting worse, as we can tell from different things now, where we're looking in the journals and things of that nature. The other thing that's very interesting is that on the back end, once she was incarcerated and she was getting treatment, the correct treatment, she got better. And that's when she got the Celexa and the Abilify. And those medications were working. And it's sort of what you were just told a second ago. You have to have a stabilizer. And that's what she needed, was the stabilizer. It stopped the voices. It stopped what was going on. We go back to the 19th of March, and you see what occurred. There's no reason why Carly should have gone and shot her mother. There's no reason. What's equally weird about this whole situation, and it was in the state's opening, they talked a little bit about it. She crossed her arms. Again, very bizarre activity. She's singing to the dogs. And the most bizarre thing that occurs is this. She wants to go after Heath. Why? There is no reason. She calls her friends over. Friends are fine. If she's some sort of psychopath wanting to go shoot 500 people kind of person, if she's calling people over, those would be some of the people that she would, I guess, target. But no, what happens is she's reaching out for help. She's in a mental health crisis. You heard the video that, or the audio, I guess, of Heath when Heath was when he arrived home, opens the door, and gets shot at. He took the stand. He tells you to this day that wasn't Carly. The person that was shooting at him was not Carly. It's real important. He's the last person that's seeing her right there as it's happening. This is the person who knows. This is the person that sees her every day, that knows Carly. And yet, he's saying, she's shooting at him. If there's anybody that has a reason to, disavow Carly and say, hey, look, she shot me. I don't want to have anything to do. She killed my wife. He's sitting there saying, and he was doing it to his own detriment, and he's saying, that's not her. Something's wrong. That was not her. And that's what he was trying to convey to you. Now, the next thing we have, can I play the video real quick? Will you help me with that? We have the video from Hinds County Sheriff Officer, or Deputy Shack. And we played it. And if you remember, the last thing that he says before, I guess it would help if you have the last thing, and we put it to, move it up a little bit. The last thing that he says before he mutes his body cam, listen to what it is. He says something to the effect that she doesn't know about her mother. And before we go back and listen, remember what Shaq said, why he was muting it. He said it was a personnel issue. If she doesn't know about her mother, that she is shot, and all this stuff that's gone on, she doesn't know what's going on. That's why that's important. And I want you to listen to it. You're going to be able to take this back and see and hear this video again. There's a policy, and I put the policy in evidence, just so everybody's clear. They cannot do what Shaq did. They cannot mute it. They don't have, yeah, you can go ahead. We're going to watch it. How much? Okay. Go ahead and stop it.
Let me back up and go around.
I'm running out of time, so y'all will have to look at it. But this is, when you go back in the jury room, you have some decisions to make. And these are the decisions that you have to address. You can find her guilty. You can find her not guilty. And when you If you find her not guilty, you have two different options. It says not guilty by reason of insanity, and then you have to see if she has been restored to reason. If she has, then she's finished at this court. The other option, and this is what you have to look at, is you can find her not guilty by reason of insanity and that she has not been restored and that she's a danger to the community. And what that means is she goes to the state hospital or somebody comes, so she gets evaluated. And they make the decisions on what happens to her. So when I'm telling you this is not, she has the keys and she's walking home. That's not what happens. We believe from all the testimony, and you can look on it here, you have the father saying it's not her, and then you have Shaq saying she doesn't know what happened. When you see those, that tells you she doesn't know what was going on at that time. We're asking you to find her not guilty by reason of insanity. And then you have to make the decision, was she restored or was she not? If she's not, she gets evaluated by the state hospital. They determine what's going to happen to her. That's what we're asking for. We want you to find her not guilty by reason of insanity.
State has 18 and a half minutes. We won't start the clock until you get everything. Yes, ma'am.
I have some of your exhibits, Your Honor.
If you would just return them up here to the exhibit table, please, sir. Yes, sir. Restroom break? All right.
I would love that.
All right. If y'all don't mind, we'll sort those out in a moment. If y'all have a seat for just a second, we'll sort out the exhibits. One of the jurors has indicated they need the restroom. We're going to take a brief restroom break, all right? Everyone remain seated while the jury exits. Y'all just knock and let us know when you're ready, okay? Correct. All right, record will reflect we're outside the presence of the jury. Juror need a restroom break. We're in recess till they knock on the door. Not a minute longer. All right. All right, jury's not ready yet, but for everybody in the audience, once they are, you don't need to be talking, okay? Once the jury comes in, there's no talking. Y'all are free to talk now, just not when the jury comes in. Do you have everything you need set up?
Yes, sir.
I got just a question on I know like where we were talking about where we had to burn discs and everything. Is there something already back there, or do they have to undo all this?
They have to undo all that, take it back there. That's all we have. All right, for everybody in the courtroom, I've been informed that the jurors are ready. Please no more talking. Everyone remain seated while the jury enters. Bring them in. All right, final closing by the state.
May I proceed, Your Honor?
Yes, ma'am.
Let me pick up right where Mr. Kent left off, ladies and gentlemen. What he was telling you is that if you find the defendant not guilty by reason of insanity and you decide that she's been restored to competency, she'll walk out the door of this courthouse. You heard about voices. Let me tell you whose voice I'm talking about today. Ashley Smiley. Ashley Smiley's voice matters. Because of Carly Gregg's actions, we will never hear Ashley Gregg's voice again. Ladies and gentlemen, you heard the very last noise she made. Carly Gregg, her daughter, took a gun, walked across the house, pulled it out on her mother, fired once, you hear her mother scream. Fired twice, you hear her mother scream. 1, 2, 3, 4, you hear the third shot, ladies and gentlemen. You saw that awful picture. You saw the stippling. You saw what she did. That person has not been restored. That person was never insane to begin with. You know what you didn't hear the defense attorneys talk about? The insanity standard. You know why you don't want to talk about the standard? Because they can't prove it. They can't prove it, ladies and gentlemen. You know what they tried to stand up here and say? The state hasn't told you why. Ladies and gentlemen, when we talk during voir dire, what do we talk about? That's not the state's burden. You won't find one place in the jury instructions that it tells you that the state of Mississippi has the burden to show you why Carly Gregg killed her mother, to show you why Carly Gregg attempted to kill Heath Smiley, to show you why Carly Gregg removed that camera that caught her actions and hid it into the refrigerator. That's not our burden. Our burden is to show beyond a reasonable doubt that she did it. And the defense attorneys have admitted that she did it. Let's talk about who needed help. Ms. Todd wanted to talk about Ms. Gregg needed help. Ladies and gentlemen, I submit to you that the two people that were begging for help was Ashley Smiley and Heath Smiley. We heard the 911 call. He says, "Oh my God, she's killed her mother and she tried to kill me." He says on there, "Please help. Send me help." He tried to say that, oh, now maybe Carly didn't mean to kill me. Ladies and gentlemen, I don't know why he's saying that, but I know that she shot him 6 inches from his head. And I know that she told Brooke, wait for her friend, that I put 3 in my mom and I got 3 more waiting for my stepdad. You think that sounds like an insane person? No. That's a person that knew this gun right here, this .357 Magnum, had 7 rounds. That's a person that knew that she'd put 3 of them in her mama's head. She had 3 more waiting for Heath, and who knows what she was doing with the last one. The why doesn't matter. They want to talk about the doctors. Dr. Pickett this, Dr. Clark that. Y'all heard him. Dr. Pickett said, yes, this is the first time I've had to testify in a criminal trial. But I have evaluated over 100 people for competency and sanity. You heard from Dr. Gugliano when she took the witness stand that she's done hundreds, if not more, evaluations of sanity and competency. Let me tell you what you heard from Dr. Clark. When the defense went to tender him as a forensic psychiatrist, he said, no, that's not what I am. I'm a child and adolescent psychiatrist. Did he render any opinions specific to children? No. Does his diagnosis of Carly Gregg matter? No. When you look at the standard in the state of Mississippi to be able to prove insanity, all right, she has a mental illness, right? I think we can all agree that those records state that from the time she was a small girl until we sit here today, that she has anxiety and depression. Ladies and gentlemen, it is undisputed that anxiety and depression do not cause someone to commit murder. It is undisputed in this courtroom that Kevin Gregg, if you believe his diagnoses, if you believe he was bipolar, schizophrenic, drug addict, all of it, does any of it matter? No, because you know what he didn't do? He didn't kill his parents. Ladies and gentlemen, the diagnosis doesn't matter. You heard, and I made notes of it, when Dr. Clark was testifying, Michael Smith was asking him, did she know right from wrong? That's what we got to know. Did she know right from wrong? He says, well, she knew something about what happened. Okay, well, she knew. Then he goes further and he said there was some level of awareness about what she was doing. Let's talk about that, ladies and gentlemen. She knew where she was. She knew who to call. She knew her mom's passcode. She knew where the loaded weapon was. You have pictures and evidence. There were other guns at the house. She didn't go pick up that unloaded shotgun and take it in there to where Mama was. No. She went in there with that .357 Magnum that she knew was fully loaded. She knew to text her friends. She knew to FaceTime her friends. She called them by the right name. She called them by their nicknames. She said, I fucked up. She said, don't call 911. You know why, ladies and gentlemen? She wasn't done with her plan. We don't have to prove why she wanted to kill Heath Smiley. All we know is she did. All we know is that after she killed her mom at 4:14 in the afternoon, she lied in wait, sent a message to her stepdad saying, hey, honey, when will you be home? She knew not to do it from her phone. She did it from Mom's phone. When will you be home? Because I'm waiting for you. Sends him a thumbs up. Then when he comes in the door, what's she do? Points the gun at his head, ladies and gentlemen. She knew exactly what she wanted to do. And then when she wasn't sure if she was successful, she ran. Insane people do not run because they don't know right from wrong. Insane people do not tell people, I need help, because they don't think they've done anything wrong. Insane people do not flee the scene. Again, they do not know right from wrong. Carly Gregg knew everything she was doing that day. What Dr. Clark said from the witness stand is that he wants you to put all your common sense aside. There's a whole stack of medical records. He says, I didn't really pay much attention to the medical records. Not any of those other providers that actually treated Carly that said there was no mention of voices. There was no mention of lapses in time, these disassociations. But you know what I'm going to rely on? Oh, wait, no. I also didn't look at the text messages. I didn't think it was important to know what the defendant was doing at the time of the crime and between when she killed her mom and when she attempted to kill her dad. That wasn't that important. You know what's important? What the defendant said after she's been arrested for violent crimes. That's what he relied on, ladies and gentlemen. He said, well, Carly said that there were voices before. Pretty convenient, right? We talked in voir dire on Monday about why do people lie? Why do people lie? Protection. Dr. Clark said on the stand, Lexapro doesn't cause murder. Lexapro might cause people to be more prone to suicide. Lexapro does not cause people to murder. Dr. Clark said on the stand that disassociation, that's what Carly had, right? That's what he diagnosed her with. But he couldn't say that disassociation causes people to commit murders. In fact, what he said was that people tend to disassociate when they are experiencing trauma. Let's think about that. Common sense tells you if someone's in a disassociated state, they don't know what's going on, it's because they are on the receiving end of the violence. They're sex trafficking victims. They're prisoners of war. They're not children that are mad at their parents because they found out about their secret life. The defendant who has never reported, even to Rebecca Kirk, who she said she loved and trusted, she never reported voices to Rebecca Kirk. She never reported these lapses in time. In fact, you didn't hear that from any provider that's ever seen Carly. Let's take another step. Then, Carly doesn't stop there, ladies and gentlemen. She tells Dr. Pickett, oh yeah, I was still having one of these moments. So let's talk about, she's safe? Heck no, ladies and gentlemen. She's claiming that she's still having those moments while she's in our courtroom. During one of our hearings, she's saying she was in one of these disassociated spells. During her evaluation with Dr. Clark, she reported that she was having one of these disassociated spells. During her evaluation with Dr. Pickett, she was claiming she was having a disassociated spell. But you know what? She remembered every bit of it. I find it interesting that she told Dr. Clark that she has nightmares. She hears gunshots. You don't hear gunshots if you don't remember them. You don't have PTSD from an event that you don't recall. She told Dr. Gugliano that she gets queasy. She gets sick to her stomach when she thinks about what happened that night. I would too. Ladies and gentlemen, unfortunately, we've seen the pictures. We know what she did. That's not the face of someone who's insane. We don't have to prove the why. When Dr. Gugliano asked her, Carly, what's bothering you the most right now? She said, I always ask patients that when I'm evaluating them. Carly said, I'm missing school. Think about that. Not, I miss my mom. I'm so sorry that I did this. Oh, I hate what I've done to my family. I'm missing school. I asked Bennett Germany when he took the stand, you and Carly are still great friends, right? He said, best friends. Y'all talk all the time? Yeah, all the time, even now that she's in jail. I said, Bennett, on any of your calls, any call, has Carly expressed remorse for what she has done? He took that stand and he said no. I want to talk about Bennett too. He said, while I was asking him a question at some point, he said, I'm sorry, can you repeat the question? I zoned out. Ladies and gentlemen, we've all had a moment where we've zoned out. We've all had a moment where we've driven down the road and got there and thought, how did I get here? I don't remember, but I knew I drove here. I tell you, when I have those moments, I'm not insane. I know exactly how I got there because I was the one driving the car. I know right from wrong, and Carly knew right from wrong that day. There is no record, no medical record of Carly hearing voices before this. I want to talk to you about some of the things, some of Carly's actions. Let's talk about some of her willful actions. First of all, I want to show you these two. Let's not forget this. These were recovered from inside Ashley Smiley's brain and neck. Who put them there? Carly Gregg. Carly Gregg's willful actions. Let's talk about that. We talked about she knew where her house was. We talked about she knew that her mom was upset with her. She told Dr. Pickett, yeah, my mom was very upset. The defense wanted you to believe that everything was hunky-dory that day. It wasn't. We've seen the videos. She may not have been yelling, but she sure was upset. We know that Carly knew her mom's password. We know that she intentionally pulled the trigger not once, not twice, but 3 times, shot her in the head. We know that she called her friends over. We know that she told them don't call the police. We know that she wouldn't let them know what was going on. We know that she tells Brooke, right? Let's talk about the tampering with evidence. She tells Brooke when she comes in the house, when the first thing she asks is, are you queasy around dead bodies? Ladies and gentlemen, use your common sense. What does that mean? I know if I'm asking somebody that, it's because there's a dead body. She knew that she had killed her mom. She tells Brooke, I got 3 waiting for my stepdad. She knew that she was going to shoot her stepdad. She also tells Brooke something important. Oh, don't worry. I pulled the cameras down already. I pulled the cameras down. She knew enough to rip that camera off of where it was, hide it in the refrigerator. Was it a perfect plan? No. Nobody ever said her plan was perfect. That's why we're here. But ladies and gentlemen, that's not insanity. That's not insanity. I want to talk about Deputy Shack and his interaction. Mr. Camp said, oh yeah, he's saying she doesn't even know about her mother. We heard from Deputy Shack. He took the stand. He said she never asked about her mother. Ladies and gentlemen, you know the only person she asked about in her interaction with law enforcement? House Heath. You know why? Because the only thing Carly Gregg didn't know from that day was whether or not she was successful in killing Heath Smiley. That's the only thing she didn't know. Again, the defense wanted to talk about it's the highest burden of proof. We have the highest burden of proof in criminal law. The state of Mississippi has to prove beyond a reasonable doubt that Carly Gregg intended to kill her mother and did kill her. We have done that. They don't dispute that. We have to prove that Carly Gregg intended to kill Heath Smiley and was unsuccessful. They don't dispute that. We have to prove that Carly Gregg intended to remove evidence and hide it. We've already proved that. They don't dispute that. The only thing that the defense wants you to do is to have sympathy for the defendant, to believe this story that she's made up after she's been arrested. Dr. Clark talked about that on the stand, right? He admitted that there's research out there that shows that there is a large population of people that claim disassociation after they have committed homicide. And we asked him, why? Secondary gain. What's secondary gain? So I don't get in trouble. Pretty convenient. If I don't remember what happened, I was having an out-of-body experience. Maybe they can't get on to me. Ladies and gentlemen, don't fall for that. That does not make sense. I want to talk about some of Carly's journals and some of the text messages. The text messages are in evidence, the ones that she sent to her friends between the time she killed her mom and when she attempted to kill her stepdad. One of them's not, but Thad testified from the witness stand that after he showed up at her parents' house, he and Carly were having a discussion, and Carly said, oh yeah, my mom was holding me down in the chair. She wouldn't let me come out there. And then she texts him later and says, I almost murdered my parents. She was so mad in February that she tells Thad, I almost murdered my parents. And then when I asked Heath about it, when he took the stand, he said, no, Carly wasn't mad. Carly never was angry. He says, Carly never yelled. Ladies and gentlemen, she told us in February what she was going to do. I want you to look at her journals. There's a page back there that says, what do I believe? There's no God. Heaven and hell are false. You writing your own destiny. And these two stand out to me, ladies and gentlemen. She told us what her intent was. You don't need family, and it's okay to be evil.
2 minutes, man.
There's another one I want you to look at. Dr. Pickett talked about it. She wrote, water, fire, earth. Water, fire, earth. She circles fire, ladies and gentlemen. And she wrote, these are Carly Gregg's own words. Ms. Todd stated when we got started the other day, what's better, watching a video of what happened or hearing somebody talk about it? Well, I submit to you, we have all of the above in this case. We got to, unfortunately, watch a video of what happened. We've seen photos of what happened. We have audio of what happened. We have the defendant's journals and text messages telling us what happened. She says, I choose fire. It is powerful, beautiful, and deadly. These are the traits I desire, so I choose fire. Ladies and gentlemen, that lady right there chose fire. She chose to murder her mother, tried to kill her stepdad, and then tried to cover it up. We ask that when you go back to the jury room, that you'll look at all the evidence, that you'll consider the testimony that you've heard, that you will not be misled or confused by the fact that the defendant tried to put a burden on the state that does not exist. We do not have to prove the why. We will likely never know the why, but we know that Carly Gregg is guilty of murder, attempted murder, and tampering with physical evidence, and we ask you to find the same. Thank you.
All right. I need Mr. Don Bass and Mr. Philip Hunt to stand, please. Apologize, gentlemen. I've watched y'all. Y'all are paid a lot of attention, but y'all are the alternates. At this time, I'm going to ask Madam Bailiff to escort them to the other courtroom if it's open, or the other jury room if it's open. Please gather your things out of the jury room, though. Once the bailiffs let me know that the alternates have been separated, I'll release you to begin your deliberations. Please do not begin your deliberations until you receive the instructions of the court and all the evidence. Many times jurors find it helpful to pick a foreperson from among their group. Foreperson has no more power than any other person. Highest qualification is you should be able to write legibly so we can read any verdict, okay? Second thing a foreperson can do is call for a vote. Many times disagreements can be resolved by simply calling for a vote and finding out where everybody stands, all right? That being said, let me know once they're separated. Did everybody fill out a lunch menu too? Okay. All right. They're separated. All right, ladies and gentlemen of the jury, you can retire to begin your deliberations. All right, the record will reflect we're outside the presence of the jury. I'm going to ask both sides to make sure Mr. Shipley here has a cell phone number where you can be reached, both sets of attorneys. Within 10 minutes of the jury reaching a verdict, I expect y'all back in the courtroom ready to go either way, okay? I want y'all to get together, make sure all the exhibits are present and accounted for, and that any exhibits marked for identification are separated. All right, we'll remain in recess until such time as the jury reaches the verdict.
Know something about the crime and that those phone calls are placed to those people in close temporal proximity to the homicide or event that I'm interested in.
And how, when you speak about the fact that there are some calls that are made off pin and some calls that are not, how do you determine when a call is made by a person that you are actually seeking to gain information from?
There's a number of factors that go into that. One of the most basic and easiest to explain would be I just recognize the voice. If we're talking about the inmate, like if I want to verify that it is in fact an inmate that I'm interested in that's placing the call, then I just develop a familiarity with their voice through various means. Wherever I can find a known exemplar of their voice, then I listen to that and I learn their accents and the tone and tenor of their voice. And that based on a few other things, like, for example, how often the inmate customarily calls this number. If I know that that number belongs to somebody that's a close family member or friend of the inmate, then that's another thing that is kind of an indicia of reliability that is in fact the inmate that's calling that number. But I think the primary thing is just knowing their voice.
Is it a common practice to, once you have done these things that you've described for the jury, for you to then talk to people that have not been identified?
I couldn't hear what you said because y'all were both saying something at the same time. Objection, what?
Leading, Your Honor.
Overruled.
Is it a common practice for you, once you have done all these things that you have described for the jury, for you to talk to people or endeavor to talk to people that have not previously been a part of the case file?
Yes.
Now, when you do that, is that something you do alone, or do you do it with the lead detective or your investigator, or a combination?
A combination.
Okay. How often is it that you have actually found people that you had not previously identified is a part of the case file, that were people you sought to obtain information from to further investigate a case?
I'm going to object as to relevance, Your Honor.
Sustained.
Okay. When you actually do locate a person and go and talk to them, do you put that in some kind of memorandum or recording that you preserve to provide to the defense?
Generally, if not invariably and always, I at the very least record the interview unless it occurred in such a circumstance where that was not possible, such as at random and it was unplanned. But if it's an interview that I'm actually planning, then I would audio record the interview, unless I don't believe I've ever actually had an occasion where the audio recorder failed. So I wouldn't even say barring the unforeseen, like the audio recorder failing. So yes, I would always record it.
And do you also provide supplements to the case file that you receive from the police?
Yeah, not in every case, but particularly if it was a case in which I did a lot of extra investigation, then I would write a supplement usually.
When do you do what you just described are called extra investigation? In what circumstances would you do what you call extra investigation?
Well, if it was
And you can explain to the jury.
in my estimation, if the case needed more investigation, if it needed extra investigation, if after reviewing the case file, I found that the evidence was lacking and that it wouldn't be appropriate to present the case to a grand jury, let alone take it to trial, then I will conduct a quote unquote extra investigation, as I called it, hoping to find more evidence to make the case better or otherwise dispose of the case appropriately.
Now, let me ask you this. What about people that have already been interviewed by law enforcement? Do you ever go out and interview those persons after receiving a case file?
Your Honor, I'm going to object again as to relevance.
Let's go ahead and move on to more targeted questions, please.
When you receive a statement of a purported witness in a case, do you take the statement given to you in the case file as all that witness has to say, or do you ever endeavor to go speak with them yourself?
Sustained.
Do you do anything with the witness statements that you receive in your unindicted cases that you get from law enforcement?
Objection, relevance.
Your Honor, that goes directly to his practice, his way of conducting investigations into the cases that he then makes other decisions for, and it goes to how it allows the jury to gauge his practice, his
Counsel approach, please.
there was a lot of cell phone records that I obtained from another investigator that I did not obtain from Detective Thorpe. And that is specifically when I say another investigator, I'm talking about Tyrone Dennis.
Okay. Now, if you would, slowing down a little bit more. If you would, please tell the jury how you determined that Detective Dennis had information of interest to you in this case.
Well, I met with Detective Dennis sometime in, I believe it would have been January 2016, sometime in early 2016.
Did you meet with him with Detective Thorpe?
No, I believe it was Detective Dennis and Lakia Gaither, and I met them at the Atlantic Police Department's public safety headquarters in a large conference room.
Okay. Okay. Pause. So, when you first got this particular case with the individuals listed that you just named, for whom warrants had been taken out, did you follow the same procedure that you described yesterday for the jury to gain additional information
Yes.
in order to assess the case?
Yes.
Was there anything that you knew personally about any of the people for whom warrants had been taken that made you decide to go out and seek additional information in this case?
Are you asking me, did I personally know the defendants, the people that the police charged?
Yes.
No, I did not know them.
Did you know when you got the case file when it was that Detective Thorpe had talked to Spencer Wright?
It would have been in October of 2015 on the night of his arrest.
And did you have, as part of your case file, information that immediately after talking to Spencer Wright or Nicholas Robinson, that Detective Thorpe took out the warrants for the persons you just named?
So Spencer Wright was arrested on October 19, 2015, the same being the night that Detective Thorpe, among others, interviewed him. And the warrants, and please correct me if I'm wrong, but I don't think I am, were taken out October 20th, 2015. For the 4 defendants that I referenced earlier for the murder charges.
Where did you have surveillance video from in the file that Detective Thorpe gave you?
So there was from what I recall, 2 surveillance cameras mounted on the barbershop located at 330 McDaniel Street. And then you went about maybe 100, maybe not even 100 yards away. There's a gravel lot and then a street. There's a Texaco station, McDaniel and Northside Drive. And I had surveillance images from that station.
Were you personally familiar with that location? Have you gone out and personally seen it?
Yes, I've been to that location before, yes.
After you got Detective Thorpe's file, did you find yourself out there again, or did you go use what you had to make any kind of determinations?
Yeah, I drove by there a couple of times, a few times, as I looked over the case just to get the lay of the land, because you can only see so much from Google Earth.
All right, so backing up, when you say you drove by there a couple of times, did you just like drive down the street, or did you stop? What did you do?
I drove down the street, I would stop, and I would just take a look at the lot just to get a kind of, rather than the 2D perspective that you would get on, like I said, Google Earth. I wanted to just kind of see where all the buildings were situated and that kind of thing. I mean, I didn't get out and like linger around, get out of my car and like linger around or anything like that. I didn't really see any reason to do that. But yeah, I did like survey the crime scene.
Why did you do that? Why did you go out there if you already had the surveillance footage?
Again, just because it's one thing to look at a scene on a screen, where you can get some 3-dimensional perspective from the images. It's quite another to actually be at the scene and not be staring at it in 2 dimensions from a computer screen. You know, you get to see, where somebody's view would be obstructed depending on where they were standing and that kind of thing.
Okay. Is that the only thing that you get of value by going out to a scene after you get a police file? Like
Yeah.
where somebody's view would be obstructed. You're allowed to tell the jury what value you gained from going out to the scene.
Well, I mean, it's just important to see where the crime actually occurred. Sometimes, particularly if it's like in an apartment complex, going out to the scene, you can do a witness canvas, start knocking on doors.
Did you do that? Have you done that?
I have. I didn't do it in this case because this occurred on a public thoroughfare.
Okay.
But yeah, anywhere where there's a homicide, where there's a lot of people, like pretty much an apartment complex or a neighborhood, I found that can be beneficial.
All right. Did you also mention Google Earth earlier?
I did.
Why did you mention Google Earth?
Well, Google Earth, in this specific case, I went to Google Earth because I did eventually end up interviewing Spencer Wright myself.
Without talking about what he said.
Right. And right. Well, I'm not even going to get into what he said. I just went to Google Earth to to take still shots of images that were photographed by those Google Earth vehicles, I guess, just so I could show them to him and say, okay, well, where were you at this time when you said you saw this, et cetera.
And had he said those things previously in his interview with Detective Thorpe? Had he given the information of where you were at this particular time? Without saying where he was, had he given that?
He offered a verbal description of where he was.
Did you capture whatever it was that he said verbally in the Google Earth photos that you then chose to show to him?
Objection, Your Honor, hearsay.
Objection, what?
Hearsay, Your Honor.
Overruled.
After listening to Detective Thorpe's interview with Spencer Wright, did you attempt to find on Google Earth where it was that he was located?
I did.
Were you able to locate an area that coincided with or matched the area he described being in?
Your Honor, I'm going to object to any reference to statements made by this witness who's not testifying as hearsay.
Your Honor, this witness is not going to tell the jury. First of all, we're not offering it for the truth of the matter asserted. We're offering it to allow the jury to see what Mr. Sprinkle did in context. He located a certain area.
Let's not say what he did. We need to hear that from the witness.
Okay, so it's provided.
Overruled.
Thank you. So, were you able to see that area described by Mr. Wright on Google Maps?
Yeah, I found an area that I believed he described, yes.
Why are you looking for the area where Mr. Wright described?
Well, specifically, because the area that I believe he described was also captured by the surveillance camera that captured the incident.
Okay.
So if Mr. Wright was where I believed he was based on what he said, then it would be in the surveillance footage. I would see him, or a human-like figure. Given the clarity of the surveillance footage, it wouldn't have been sufficient to actually make out his face, but I would have at least expected to see that.
All right. Did you see Mr. Wright or a human-like figure in that area you were looking at on the surveillance footage?
I did not.
Did you fully capture that area on the still shots that you took down to show to Mr. Wright?
I did.
When did you meet with Mr. Wright?
This would have been January 12th of 2016.
Where did you meet with Mr. Wright?
The Atlanta City Jail.
Now, was Mr. Wright being held on felony or misdemeanor charges?
It's a probation violation on a felony case.
Now, did you offer anything to Mr. Wright in exchange for him speaking with you?
I didn't.
Had, to your knowledge, anything been offered to Mr. Wright by your office in exchange for him speaking with you?
Not to my knowledge.
Was there any insinuation that you would lower his charges or drop his probation warrants?
Not by me.
Okay. Was there any made by anyone associated with you that you have any knowledge of?
No, not to my knowledge. I have absolutely no information to indicate that that ever happened.
Okay. Who went with you when you talked to Mr. Wright?
The aforementioned, the investigator I mentioned yesterday, David White.
How long, do you remember how long you met with Mr. Wright?
Probably like maybe like an hour. I audio recorded it, so however long the audio recording is how long I met with him. Well, for in relevant part. And I audio recorded the entire thing. It would probably 45 minutes to an hour and a half, I would expect, somewhere in there.
Did you video record it as well?
I did not. In fact, I brought a voice recorder no, I just brought a pocket voice recorder.
Now, why weren't you in an interview room video recording you all's interaction?
It was actually in a pod, like an inmate dorm at the Atlanta City Jail where Investigator White and I interviewed him. And there was like a little, like a break-off room to the side of the pod, and we just met him in there. There was a table and chairs in there, and we just talked to him.
And were any other inmates around while you talked to him? Present?
Well, they weren't in the room with us. I don't recall if they were out and about in the dorm. But yeah, there were other inmates. I don't recall that any of them were within earshot of us, though.
Not within earshot. Is that what you said?
I don't know. Certainly nothing happened during the interview that alerted me that somebody was listening in. I'll leave it at that. And I don't recall having a feeling at the time that, because I believe I would have. That would have left an impression on me if I thought that others were eavesdropping, and I didn't have any feelings of that sort while I was doing the interview.
Now, how many images did you show to Mr. Wright?
I don't know exactly how many. Let's see. Probably like 15 to 20.
Were all 15 to 20 images that you showed to Mr. Wright?
Probably more like 10 to 15, actually. It was somewhere around there. It was less than 25.
Were all of the images that you showed to Mr. Wright images captured from the barbershop footage in front of which the murder occurred?
Yes, it was Google Earth still shots that just depicted the scene. Okay. And still shots from the barbershop surveillance footage.
Starting with the Google Earth still shots that depicted the scene, what did you do with those still shots?
I printed them out prior to going into the interview.
And when you showed them to Spencer Wright, given that they weren't from the actual night of the murder, what were you doing with them?
Well, given that the scene had remained, from the time the murder happened to the time that the Google Earth vehicle photographed the scene had remained unchanged. In other words, the lay of the land was essentially the same. Mm-hmm. My objective was for Mr. Wright to identify where both he was and other parties were at various times during when he witnessed the incident, according to him.
Okay. So was Mr. Wright, without saying where or what he said, but was he able to point out an area that he was claiming to have been at?
Yes, he did.
And was that area also captured in the surveillance footage from the barbershop?
It was.
Now, was the lighting the same on the Google Maps images that you showed him as it was on the night of the murder that was captured on surveillance?
No, because the Google Map images were captured during daylight hours, whereas the homicide occurred during just after nightfall or during twilight hours.
Were there any identifiable landmarks in the area that you were interested in regarding Mr. Wright that were clearly depicted on the Google Earth printouts?
What?
Stationary objects.
Well, there was a bench, yes.
Okay.
Mhm.
And where was that bench located?
It was located at a bus stop.
Where?
Where's the bus stop?
Yes.
It's across the street from 330 McDaniel Street.
Okay. About how far from 330 McDaniel Street?
However wide the street is, I don't know, 30 yards, 40 yards.
Okay.
Because it wasn't like directly across the street. I mean, it was sufficient that it was captured within the surveillance footage, but it was kind of, I guess it depends on how you define it. It was definitely across the street, but if we're going through the front door of the barbershop, it wasn't directly across the street from the front door. It's kind of like diagonal. Yeah.
Diagonal? All right. Is that bench visible on the surveillance footage?
It is.
Were you interested in looking at a particular time on the surveillance footage after listening to Mr. Wright's interview and speaking with him yourself?
I was.
And what particular time were you interested in looking at?
Time isn't a constant here because there's the time that I believe the incident happened, and then there's the timestamp on the video, which differed.
Okay. And so let's start with the time that the incident happened. If it's different than the time on the video, how do you go about finding what time to look at?
Well, I'm watching the video. If you, in this case, you have a surveillance video, and the incident of which we're speaking is prominently featured when you watch that video. So I could just watch the video and wait for that incident to occur, and that's when I knew that the portion of the video that I was viewing was relevant insofar as it depicted the incident, regardless of the timestamp emblazoned thereon.
And during that time that you're looking at the video, are you able to discern where that bench at the bus stop is in relation to where the shooting occurred?
Like it was about, like I said, across the street, not directly across the street, but probably across the street and maybe 20 to 30 yards to the right if you're facing across the street from the barbershop.
Did Mr. Wright recognize the bench in the surveillance footage, or were you able to show him the bench in the surveillance footage?
In Your Honor, calls for hearsay and also confrontation clause.
Sustained.
I would withdraw that. Did you ever see Mr. Wright in any part of the surveillance footage of the murder, or someone fitting his description anywhere near that bench? And by anywhere near, I mean sitting on or within 1 foot of the bench during the time of the murder.
No, there were no human-like figures around the bench. I saw a cat at one point.
You saw what?
It looked to be a cat.
A cat. You could see a cat on the surveillance video?
Yeah, that's what struck me. It wasn't real high fidelity, but it was, the light was bright enough and the fidelity was sufficient to see a feline moseying around the bench, but there was unambiguously, there were no people around the bench.
Did you check the surveillance maybe like a few minutes or minutes after and minutes before the murder just to see if perhaps there was a human at that bench?
Oh yeah, I'm sure I did. I watched that footage many, many times. Of course, the most relevant period to me was the time when the incident actually occurred. But no, I didn't see a human at that bench.
And how many times did you watch that video?
I didn't keep count, but it would have been many, 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 many times. So at least 150 to, I don't know. It was many times.
Why did you watch the video so many times?
To see every time I
Tell
watched.
the jury.
Every time I watched, I was hoping to see something maybe I hadn't noticed before, the way the light bounces off one of the vehicles, because that was a big part for me. I wanted to figure out what sort of vehicles we were dealing with here. I actually had the video enhanced at one point because, like I said, the video wasn't very high quality. So yeah, I had to kind of try to fill in the blanks myself. That's why I viewed it so many times. And also just I always would hope. A lot of times it would probably just be in futility, but I would always hope to see something I hadn't seen before.
Now, when you said you had the video enhanced, would you tell the jury what you mean? I mean, when you say enhanced, what did you do?
I sent it off to private corporate companies or individual. There were two. It was Target, like the retail store. They have a division within their company that deals with surveillance footage, and they at the time, maybe they still do, but they at the time they would digitally enhance surveillance videos. And there was another gentleman named Walter Pineda who offered the same services. He was an individual.
Why did you send it out to two different places?
I guess the more the better.
Were either of those places able to allow you to see anything more clearly in the video?
A little bit. Yeah, it helped a little bit. Yeah, it's digital. So there's really only so much they can do to clean it up. It's just ones and zeros. But they are programs that can, I guess, kind of filter out some of the noise from the picture and that kind of thing. And that's what they did. So it helped a little bit.
Now, is it unusual for you to take surveillance footage in unindicted cases you receive from law enforcement officers and send it off to other agencies to have it, to see if you could have it enhanced at all?
Your Honor, relevance.
Overruled.
It is actually, I think this is the only case I've ever actually done that on.
And why then did you choose to do it on this case?
Because the video was so important and I really needed to identify as much as I could in that video.
Now, was this, when you say the video was so important, was this particular homicide case for you any more important than the others or any others that you worked on, the case itself?
No, it wasn't any more important. Any case, it got more attention because for my purposes, it was essentially unsolved right when I got it. And so that elevates the priority of any homicide case. Now, I wouldn't say priority isn't the right word. It really isn't. It's just the amount of time that I'm going to spend on it certainly goes way up.
Okay. And when you said it got more attention because it was unsolved, how often did you get unsolved cases in your capacity as an unindicted homicide?
Objection, relevance.
Overruled.
Not very often, thankfully. The police don't normally make charges on.
Relevance and non-responsive.
Sustained.
Okay. So,
Sustained.
all right, when you say not often, can you tell the jury approximately how many unsolved homicide cases you've worked with during your time? And it doesn't have to be an exact number. Because my follow-up question is going to rely on.
Maybe 20 to 30 truly unsolved cases.
In those other 20 to 30 cases, did you perform acts or investigations in the same manner that you performed your investigation or further investigation of this particular case?
I did.
And did that include seeking out witnesses that had not previously been identified?
That is correct.
Did that also include finding jail calls
It
that
did.
had not been identified?
It did.
Did it include going out to scenes?
It did.
Did it include interviewing people who had already been interviewed?
It did.
And do you, with those other cases, did you include as part of the case file, recordings that you conducted, recordings of persons that you conducted interviews with?
Yes.
And did you include any cell phone data, jail calls, social media, things of that nature that you found during your independent investigation of the case?
I did.
And after you got the video enhanced of the barber shop, did you review any other, or I should say, did you review any other video besides the barbershop video?
I did. There was that video from the Texaco station. I reviewed that.
The video from the Texaco station, were you familiar with how to work that system when you first got it?
Well, I didn't, when you say system, I didn't receive the original recording apparatus.
Okay.
But the software, yes. I mean, I figured it out and was able to view the video.
When you first got that video, was the timestamp on that video the same? In other words, was the time on that video the same or different than the time on the barbershop?
From what I recall, the barbershop surveillance video is considerably more accurate than the video from, or excuse me, the Texaco station video is considerably more accurate than the barbershop video, if not entirely accurate.
Okay. So if it was different, how were you able to look at the Texaco video and determine anything as it relates to what was happening in the barbershop?
So the frames enter, there are certain parts of the frames that overlapped. So in other words, so you had a camera at the barbershop that was capturing the street, and then you had a camera mounted over at the Texaco that was also capturing that same street, and the two cameras were capturing part of the same part of the street. So if I saw something happening in one frame, I could just marry it up to the from the image caught by the other camera. And if I had, for example, and that's how I would be able to tell. So in other words, I wasn't using timestamp, particularly in the barbershop, since the timestamp was wonky. But even if the timestamp looks correct, it could still be a few seconds off, you know. So I was mostly things that were constants to me were like vehicles driving by the scene, or when gunshots rang out, you know, I would look for that. So so on the Texaco footage, I don't recall exactly. There was a blue car that came into the gas station. There was something that was captured on both cameras that I was able to use as a marking point to sync up the two pieces of footage.
Okay. When you were reviewing the Texaco footage, did you only look at the time frame that you thought that the murder occurred?
No, I particularly as I continued my review, I looked at probably like 30 or 40 minutes before the murder occurred. I looked at the entire piece of footage.
We're going to come back to the Texaco footage, but I want to ask you, after looking at the Texaco footage, did you do anything to identify persons or objects that you saw in the Texaco footage?
I did.
Would you tell the jury how you went about identifying certain persons and objects? And if you need me to clarify, ask me to clarify.
Well, there was, and without getting into, all right. So there was an event that occurred on the video. First thing is that I was looking for something specifically that, based on other evidence in the case, I'll just keep it broad or general here. Based on other evidence of the case, I suspected I was going to see on the video. And then as I watched the video during that time frame, I did in fact see what I thought I was going to see.
Did or did not?
I did.
Okay.
And it was a vehicle specifically. There was a certain vehicle, and when I saw it, based on other things that I had seen, and specifically I'm talking about social media records, photos, and cell phone tower data, I thought I wonder if this person is at the gas station. And when I looked at the footage, I said, oh, well, I recognize that vehicle from social media. And then as I continued to watch the footage, I recognized one of the people that was inside, was a passenger in that vehicle, because that person walked into the store and they got close to the camera. And because they were close to an interior surveillance camera in a well-lit store, I was able to see their face. And then as other things happened around this vehicle that I recognized in the footage, complete investigative tasks to figure out who the other people were. I already knew who one of the people was, the person that was driving the vehicle, or I had a strong suspicion as to who was driving the vehicle I was looking for based on cell phone records and social media photos and videos. So I already knew right when I saw it. I had a pretty good idea. I knew for a fact who one of the person was, and the person who was driving the vehicle, I had a pretty good idea who it was.
All right, let's unpack a little bit of that. Now, what vehicle were you looking for?
It was a 2002 Pontiac Bonneville.
What color?
Gray.
Why were you looking for, better yet, did you have a particular reason for seeking out that vehicle?
Your Honor, calls for hearsay.
I haven't asked him what anybody did.
I don't know what the answer's going to be, but it potentially could.
Let me tighten it up then. Was there a particular person of interest to you based on what you had learned during your investigation up to that point?
Objection, called for hearsay.
Sustained.
Were you looking for any particular gray Pontiac Bonneville?
There was one particular gray Pontiac Bonneville that I was interested in, yes.
All right. And who did that Pontiac Bonneville belong to?
Either belonged to or is associated with a man named Javoris Bradford.
Is there a nickname for Javoris Bradford?
Tuda, Tuda.
All right. Now, did you attempt to locate any social media footage that related to Javoris Bradford or Tuda?
I did.
Would you please turn to the jury and tell the jury how you went about locating social media accounts associated with Javoris Bradford or Tuda?
Well, I just searched for him probably on Facebook first, because particularly back then it was easier. And I either found him or a family member on Facebook, and then browsing the family member's profile. And this may not be exactly how I did it, because I don't recall exactly how I found Mr. Bradford's Instagram page. But somehow or another because on Instagram, we went by the moniker I'm_living_great at the time. Mm-hmm. And so basically on probably starting at Facebook, finding family members, fanning out, and then on finding him on Facebook, finding maybe where he screenshot an Instagram page and pasted it to his Facebook. That would be how I would have found his Instagram page somehow. And then, and like I said, his Instagram name was I'm_living_great.
And did he have himself depicted in that Instagram footage?
I'm going to object. That's hearsay.
Overruled.
What did he have himself depicted in that social media footage or social media information that he saw with any kind of vehicle in particular?
Yes, it was a 2002 Pontiac Bonneville.
Gray?
It was.
Okay. Did you ever discern or gain a number for Tuda? Did you ever learn of a phone number for Tuda?
I did, pretty early on, actually.
Where did you get the phone number from for Tuda?
So I testified previously about how I...
But don't talk about your previous testimony with this. Have you ever testified in front of this jury?
Yes. Yeah, that was something I said like earlier today.
Okay. So without referring to the fact that you previously testified, just tell the jury.
No, I'm talking about like previous testimony like a few minutes ago.
Okay, go ahead. Tell the the jury.
All right. So one of the ways I find jail calls is I go through phone records that I had in the case. And in this case, I had some phone records. And I don't recall whose phone records it was exactly. But I just started running numbers that appeared in the phone records, whether they be called, numbers that were called by the handset, the records of which I was reviewing, or numbers that called that handset. It didn't matter to me, just whatever. I was running them through the jail call database. And one of those, because like I said, I was trying to get intel. It wasn't just, obviously on the night of the shooting, the murder, yeah, I mean, I would expect that the people that committed weren't in the Fulton County Jail, so I obviously wasn't looking for inmates to be saying that they did it.
Okay.
But I was trying to get for intel from people that maybe were being called from inmates, and one of those numbers was 404-957-8008, and I'm flipping through these discs to make sure, to refresh my recollection.
Okay.
To make sure that I'm citing that. Yes, that is right. 404-957-8008 was one of the numbers that appeared in those phone records and that I ran through the jail call database. And on doing so, I did find calls that I deemed relevant that were placed on the night of the homicide from an inmate inside the jail.
So, Madam Court Reporter, and I suspect some of the jurors have informed me that you are speaking a little too fast. Do you mind slowing down and saying what you just said one more time?
Yes, I found a number inside within the phone call logs that were obtained by the Atlanta Police Department for one of the parties of interest, whether it be a person of interest or a witness or a defendant, whoever it may have been. And it didn't matter to me. All I wanted were numbers from the phone numbers of people that may have known something about the homicide and may have been called either on the night of the murder, the day after the murder, 2 days after the murder, whenever they were called.
You're getting really fast again with
All right.
talking, so try to slow down.
All right. And one of those numbers of the many that I ran was 404-957-8008. I ran it through the jail call database, and I found that there were 2 calls I was able to retrieve anyway. I think at least 2 that were placed to that number on the night of the murder from an inmate inside the Fulton County Jail, and they were placed after the 8:00 p.m. hour. I think they're maybe between 8 and 9 p.m. that evening.
Now, why did that particular piece of information have any value to your investigation?
What piece of information exactly?
That there were 2 calls made to that number by an inmate at the jail on the night of the murder, around 8, or at the time you specified.
Well, I listened to the calls, and it sounded to me like they were talking about the homicide.
All right. So, were you able to identify who it was that was inside the jail that was making the call to that number?
I did.
How did you identify who it was inside the jail making the call to 404-957-8008?
Well, I believe, would you like me to say the name?
Well, number one, I would at some point, but hold on before you do. And let me ask you this. If you need to refresh your memory with any part of your report, would you just alert us that you're doing so and go ahead and read whatever you need to read?
Okay.
Do you need to refresh your memory at all?
No.
Okay. How did you learn the name of the person inside the jail?
It was placed from the account of the inmate.
Okay. And how were you able to determine that the person whose name was on the account is the actual person who's making the call?
Well, I gained familiarity with his voice by listening to other phone calls that the inmate made to persons that were well known to him. And then I later confirmed it by just like listening to the call with the inmate.
Okay.
He affirmed it.
All right. So tell the jury who it was that was inside the jail.
Martinez Arnold.
And does Martinez Arnold, to your knowledge, go by any other name?
Duke.
All right. At the time that Martinez Arnold was inside the jail, and what date was that you are talking about? January?
It was January 10th, the phone call. It was January 10th, 2015.
During that time, do you have any information about what color Mr. Martinez Arnold's hair may have been?
At the time they placed the phone call?
No, around the time of early 2015. Do you know whether or not? If you don't, that's fine. Do you know anything about the color of his hair?
No.
All right. So once you listened to calls, did you attempt to get any more calls made from the Fulton County Jail?
I did. I downloaded a lot of jail calls on this case.
What jail calls, how did you go about deciding which jail calls in this case you were going to download?
Well, I tend to be I'll download because the jail calls don't reside on the server, the Securus Corporation server forever. I try to err on the side of just downloading them. So as I ran those numbers through the Fulton County Jails database, any calls that came back on the numbers from the phone, like the phone records, I just download them. But what would prompt me to pay particular attention to them is if they were placed in close temporal proximity to the homicide. Certainly a call placed like an hour or two after the homicide would be something I'd want to listen to. Also, I downloaded calls of the defendants that they placed following their arrests at the Fulton County Jail. I put those in the file as well.
Okay. And at the time that you were looking for the phone number and confirming, you picked up something in front of you. What is it that you have on this stack of items in front of you?
Those are just, I burned all of the jail calls. Not every single jail call that I download but most of, I tried to confine or memorialize as much as I could to this report that I testified about earlier today. It's 140 pages long. And as I went through the report.
The answer is non-responsive to the question.
Listen to the question and try to focus on answering the question that's asked.
I'm also going to object to the relevance of the length of his report.
Sustained.
What is it that those are in front of you?
They're just the jail calls that I testified to downloading and interviews that I conducted. I burned them to disk.
Okay. And the one that you picked up to refresh your memory about the 404-957-8008, would you pick that up?
Okay. There we go.
I'm going to show you what I have now labeled as 500 watt. That's the disc that you just had.
Yes, this is a disc that I created yesterday.
Okay.
That's my handwriting, and in fact, I signed the disc, my signature.
Okay.
This is a disc that contains the jail calls to 404-957-8008 that I downloaded.
Now, when you said that you downloaded it yesterday, do you keep all of the jail calls that you download in a particular case somewhere where you can later copy it to a disk, or what
They're on a server. My case file, all the case files are on a server. They're all digital. They're just stored on a computer.
Okay. Had the name Javaris Bradford come up in the case file that you received from Detective Thorpe?
No.
And do you recall approximately how long after you received the case file from Detective Thorpe that you became interested in the name Jabari?
It would have been on or around States Exhibit 5004.
I think that's 500Y.
Oh, 500Y, excuse me. All right.
Thank you, Judge. I'm sorry, I'm sorry. Terrible handwriting. What about the name Martinez Arnold? Did you know about that name? Was that name in Detective Thorpe's case file that he gave to you?
That I don't recall. I don't know that I don't recall if he was in the case file or not.
Let me ask a better. Let me ask a better question. At the time you received the case file from Detective Thorpe, was the name Martinez Arnold of any interest to you in this investigation?
I don't recall.
Did you note anywhere in your report whether or not it was?
I'm sure I referenced in my report as far as the inmate that placed the call that became of interest to me, but as far, I'll just say this, he was in jail on the night of the murder.
Okay. Before downloading those calls, did you know he was in jail on the night of the murder?
I don't know if I knew or not.
Okay. After you downloaded those calls from the night of the murder, did you find any other numbers of interest to you in this investigation?
Numbers.
Phone numbers. Did you find or locate any other phone numbers or persons that were of interest to you?
Yes.
What phone numbers did you find?
Well, yeah, I get there was a number. There was a lot of. I mean, I remember doing quite a few search warrants for cell phone numbers and focusing on cell phone numbers for or records that had been obtained by the police department.
Okay. So going back to the way you described obtaining information to conduct more investigations, did you follow the practice that you ordinarily follow in terms of search warrants to get more information, to gather or follow up on information you learned?
Yes.
All right. With respect to Spencer Wright, did you ever seek any jail calls from him?
I did.
All right. Now, where did you look to find jail calls from?
Spencer Wright?
Yes.
Well, I wasn't able to look for the jail calls myself for him. They were on a different system because he was at the Atlanta City Jail, so I reached out to someone there and asked them to pull them for me.
So thank you for clarifying that. Is reaching out to someone at a different facility with access to calls you don't have access to something that you did only in this case, or is that a practice that you follow to get information?
No, I've done that on other cases. It's not uncommon.
And if you slow down and speak into the mic and to the jury, say that again.
Yeah, yes, I've reached out to other facilities, jails and prisons, correctional facilities in the past to obtain calls, recorded calls placed by the inmates that I don't have direct access by way of a login and password at some website.
Okay. And so when you reached out to the Atlanta City Jail, what information were you trying to get if you didn't know or have Spencer Wright's jail calls or phone number? What were you trying to get?
I just wanted to see what Spencer Wright, I wanted to hear, I should say, what Spencer Wright was saying to people after his arrest in October of 2015.
And did you ask for a specific time frame of calls or just all of the calls? What did you ask?
From what I recall, I asked for all the calls that have been made from his account since the beginning of his incarceration at the Atlantic City Jail. And then I believe I also had a few phone numbers that I wanted to run, that I asked them to run queries specifically in the event that he utilized another inmate's account to call that number.
So that's interesting. So when you say in the event he utilized another inmate's phone number, where did you get the phone numbers that you wanted them to run to see if he was using another inmate's phone number?
That I don't remember.
All right.
I it probably just phone numbers that they're probably just it may have been the same phone numbers that I ran through the Fulton County jail database. Not knowing who Mr. Wright knew or he didn't know, I'm sure I just thought, just out of curiosity, run all these numbers. Maybe I had a phone number for a family member that I found.
Did you follow the same procedure you used in all of your other unindicted homicides?
I did.
In terms of running those numbers?
I did.
All right. Did you have jail calls, since this was 2016 that you're looking for these, did you have jail calls for Spencer Wright that went back into 2015?
I believe so. Yes, I did.
And did you find a phone number? And if you don't recall, let me know and I'll refer you to your report. And I can actually, so that it is preserved for the record. Just label this. I'm going to label, Your Honor, just for the purposes of the record, 501 Yankee Romeo. And if it's a report that we have previously provided to counsel for the defense. If either of them need to look at it, it's here.
Would this take a time for our morning break?
Yes.
Okay, let's take our morning break.
A spinal issue. He's on prescription medication. Spinal Bush, it's spelled B-U-S-C-H. And he mentioned to me that he drove to your courthouse. He did not take his medication. He has a spinal issue. He's on prescription medication.
Okay.
He was subpoenaed last night by the DA's office, told to be here at 9. He came even though, the 24 hours wasn't complied with. But I spoke with Ms. Hilton, if just as a courtesy, if he's not going to be called or used, he'd like to go home, take the medication, and sleep in bed.
We went outside the hallway. He's not there, so I'm waiting to see where he went. So I can go speak to him, Your Honor. He wasn't in the hallway a few seconds ago.
All right, so is that somebody you plan to call today?
We'll probably be able to release him, so that's all I want to talk to him to see where he is, and if he's in that condition, we'll probably release him.
Okay.
For today.
All right. Anything else? I guess we need Ms. Love back for the witness testimony.
Yes.
So do you want to, and is Mr. Sprinkle available still? Okay. All right, are we ready for the jury?
Okay, thank you.
Yes?
Yes, Your Honor.
Okay. Let's give Mr. Sprinkle and the jury, please. Thank you. Go ahead, Ms. Love.
Thank you. Mr. Sprinkle, would you refer to page 13 of your report? And if you need to refresh your recollection, just read over it and look up when you've refreshed your memory.
Okay.
All right. So did you gather phone calls from Mr. Wright that were going back as far as 2015?
Yes.
And would you tell the jury if they went back as far as November 5th, 2015?
They did go back as far as November 5th, 2015, because I obtained a call that Mr. Wright placed on November 5th, 2015.
Now, how many calls did you obtain from Mr. Wright, if you know?
The total number of calls, I do not know. I did put them on a disc though, so the disc would obviously have all the calls that I ran, but it would be over a dozen.
Over a dozen?
It'd be, I believe, well over a dozen actually.
And if you have that disc, would you pull that out?
Sure. Let's see. Here we go, right here.
All right, and we'll label this disc 501. do you know how many calls you listened to of Spencer Wright?
Several.
Okay.
I'm sure one that was of particular interest to me, though.
And was that the first call that you listened to, or did you have to listen to more than one before you got to that call?
I don't recall. I likely, unless I got real lucky, had to listen to several calls before I found that one.
Now, tell the jury, without detailing the content of the call itself, what date the call was that you found,
November 5th, 2015,
and what number was the call made to?
404-406-7784.
And is 501 Yankee the disc that you just gave to me that you said you downloaded the calls
Yes, this is
made
the
by Spencer Wright?
yes, this is the disc that contains the calls that I requested from the Atlantic City Jail, the jail calls, the recorded calls placed from either Mr. Wright or numbers that of which I was curious.
After you listened to the call, did you say what time that call was made on November 5th, 2015?
1:28 p.m.
And was that in, when you say 128, did you list it, is it listed on the recording or the CD as 128 or in military hours 1328?
It's likely 1328
Okay.
on the actual timestamp, but probably there's a second value in there as well.
Okay. And was the call between, were you able to tell if it was Mr. Wright on the call?
I was able to tell, yes.
And was Mr. Wright speaking with a man or a woman?
He's speaking with a man.
All right. And without saying what either person said, are you able to tell the jury the subject of the call?
The subject of the call was
Honor, calls for hearsay.
Overruled.
the subject of the call was Mr. Wright talking about what he.
Well,
Don't
let's,
say what he was talking about. Don't say, don't, without saying what anyone said. Let me be more specific. Was the
sorry, that was me. Yeah.
was the subject of the call Mr. Wright's presence on scene at Diamond Thomas's murder?
Your Honor, calls for
Yes,
hearsay
sustained.
and leading.
Yes.
Your Honor,
Yes.
so I'll ask this question, and if it's an objection, but did they talk about Don Nutt in the call?
Objection, Your Honor.
Sustained.
All right. Your Honor, given that I'm not asking him anything for which I'm offering the truth of the matter asserted, and it's a subject, I don't think that it's hearsay.
Okay, well, I appreciate that you don't think so.
Okay. So I'm gonna take that as you're not gonna reconsider.
Correct.
All right. So, after you listened to that call on November 5th, 2015, 1:28 p.m., between Mr. Wright and the person he called at 404-406-7784, did you endeavor to locate the person to whom Mr. Wright was speaking in that call?
Yes. Well, my first endeavor was to figure out who had that number, and then I asked David White, investigator David White, to locate him and speak to him.
All right. So back up a little bit. You said you endeavored to find out who had that number,
I did.
and was that the number ending in 7784?
That's correct.
And did you take the steps that you described for the jury earlier that you take in trying to determine what number belongs to what person?
I don't know if I went into great detail about that. I mean, there's numerous ways to figure out who a cell phone number belongs to.
Tell the jury.
I believe here, I found that somebody on Instagram posted that number in comments that were publicly visible as their number. In other words, there was an Instagram user that said, contact me at this number
Okay,
in a comment section of a post.
all right.
And then through perusing their Instagram profile, I eventually found enough biographical information. Like, today is my birthday. I don't know if that's specifically what happened here. It suffices to say that I found enough publicly available information about the person who posted that 7784 number as their own to figure out who they were.
And who did you have David White locate after you saw that Instagram information?
Are you saying the person I identified as posting that number as their own?
Yes.
The name was Jacquees. First name spelled Jocquuise. Smalls. Last name spelled Smalls.
And did you find a date of birth for Jacquees Smalls?
September 27th, 1988.
Do you remember whether whether investigator White was able to locate Mr. Smalls?
From what I remember, he spoke to him on the phone.
Did you ever personally speak with him?
No, I don't think I ever did.
Did you listen to the phone call, or did you have David White record the phone call with Mr. Smalls?
Investigator White recorded it.
And did you listen to it?
I did.
All right.
Can I interrupt you just for a minute and have counsel come up to the bench? It doesn't have anything to do with what you're doing right now. I would like to be able to put Mr. Zachary on the stand as soon as he gets here. And so if he's going to get here within the hour, then we could either do a really quick lunch right now and then take him, or we can do a late lunch after his testimony. But how long do you think his testimony is going to be?
His testimony is going to be
The rest of the afternoon?
Yes.
Okay. So, I mean, maybe we just take a quick lunch now.
Okay.
And then by the time we get back from lunch, hopefully he'll be here. Does that make sense?
It does. It does.
Okay.
I just wanted the court's direction. That's all. In terms of, because I didn't want to take Mr. Sprinkle like all the way through to the point where he's here and then we break for lunch and he's out there. And
No, I agree. I don't want him, once he's here, I'd like to go ahead and start his testimony, not say, well, it's nice that you're here, but we're breaking for lunch. So let's just break for a really early lunch right now. And you said you think he'll be here, or I don't know if you said that. The estimate from the sheriff's office is within
1 hour.
Okay. So why don't it's 10 after 11. Why don't we break till quarter after 12?
That's fine for me. And if he's not here by that time, I don't have a problem continuing with Mr.
All right.
Sprinkle until he gets here.
Okay. So if one of the deputies can just let the jury, since I told them it might happen anyway, let them know they're on break till 12:15. Miss Love, you can get hopefully whatever you're going to get in place with regard to an immunity order. And I guess you technically need to give me the motion too, but it's sort of been acknowledged in open court by Mr. Scheib that that his client is going to plead the fifth otherwise. So I understand there's a basis for needing it.
And I'll say to if he, so, Your Honor, if he decides to, notwithstanding the immunity agreement, refuse, I'll speak about it with Mr. Scheib because
He might get taken into custody.
and not by
Mhm.
and the state should not be required to
Excuse me, would you speak in the microphone, please?
So if, I'll say
Get to the microphone and then speak.
it's premature, I believe, to speak on this, but I'll just say that I would ask that the court, if Mr. I don't know what Mr. Zachary is going to do when he gets here, given everything that we've heard, but so I'll just actually wait and see. But as it relates to if there is an immunity agreement in place, we are asking, and he does not testify, we would be asking that the court send him into custody and until he purges himself of contempt of court, if the court signs the order.
Normally have an immunity
It
agreement.
is, but there's also the concern about keeping him at the jail, and there was that.
I don't know. Maybe there are other alternatives. I don't know.
Okay, that's it, Judge. Thank you.
Okay. All right. We're on lunch break till 12:15.
Thank you.
Contrary to insinuations that have been made today, I have no idea what's about to happen. However, if Mr. Zachary is not going to answer any questions, which strikes me as a possibility, I think we should determine what Mr. Zachary is going to do in his condition and everything else before the jury comes out.
What do you mean? What do you mean?
His condition, his pleasure. I don't.
No, I know what you mean by his condition. What do you mean by, I think we should determine what he's going to do in his condition?
Well, I don't know what he's going to do, but if he's going to refuse to answer questions, I don't believe that would be appropriate for that refusal to occur in front of the jury. And I don't know if he's going to do that or not. Let me be clear.
Your Honor, actually, what is, and we had this happen with another witness, and what has been, I know that what is the case law is that if the state has the opportunity to sit there and ask questions while a person continues to plead the fifth, it's not a pleading of the fifth and that causes a mistrial. It's if the state is allowed to put testimony in essence in front of the jury in the form of leading questions while a person continues to plead the fifth, and the defense does not have an opportunity to properly question or elicit any answers from that person, that's when the problem arises, not when the words "I plead the fifth" come out of their mouth. So we would ask that Mr. Zachary be allowed to be brought in just like any other witness, not be pre-questioned, and that the state be allowed to begin its examination.
All right. Mr. Scheib, you've just recently talked to your client, and you have, I presume, discussed with him the immunity agreement that you all have entered into. Is that correct, generally? All right. And so in the course of that, you would have talked to him about the fact that once an immunity agreement is in place, the pleading the fifth assertion is not basically applicable anymore. And does he understand that at this point, if he says, I plead the fifth, that he may get taken to jail and held until he decides to testify? Okay. And has he given you any indication that once brought out to testify, he is nonetheless going to still plead the fifth?
He's not going to plead the fifth, but just to say what he's going to say.
Your Honor, I object to Mr. Scheib.
All right.
I object to Mr. Scheib putting on the record representation about what his client is going to say. I would ask that the court allow the state to question the witness and under oath, and it be brought out then.
Go ahead, Mr. Scheib.
That's fine. Just also questioning, or they may do he's under, he's been taking narcotics, so that's in his system, so something else everybody's gonna have to deal with.
Okay.
So, you know.
Well, I appreciate Mr. Shive saying that. Having to deal with someone on narcotics that's going to claim to not remember anything is quite honestly ridiculous. If he's going to testify, he needs to testify. If he's not, and just going to say, I don't recall anything, then we're not going to be able to cross-examine him. If he's going to say, oh, I'm too high to answer questions, that's not effective opportunity to confront a witness. And so I don't know what's going on here. I don't know what any of this is, but if we're going to call a witness to the stand, he needs to be able to answer questions. If he can't, then I'm not able to cross-examine him.
So, Ms. Love, I know that we all discussed earlier the possibility of you needing to have a doctor come give us some information about what
Your Honor,
impact anything in his system might have?
no, actually, Your Honor, what I had asked the court to do was to get or meet with the doctor and find out his status and his ability to actually be released and come down. This was done without.
Okay, and just to be clear, that never happened, okay, so that's not confusing on the record, because we found out before you ever even were able to set anything like that up, that he was about to be released and on his way over here, right?
That was what I was attempting to say a bit too slowly. So yes, Judge, I don't think that there's any need to talk to a doctor because he was released.
Okay, so
before all of that happened.
If he comes out and he says, I am high as a kite, I'm on whoever knows what, and, beats me, I'm just loopy, that may or may not be true, right? I mean, I don't know what he's actually on. I don't know what his condition actually is. I don't know if he is on something, what impact that might have on his ability to testify. And I am not necessarily going to take his word for whether he is in a mental state to be able to testify. Do you understand what I mean?
I do, Your Honor. And since that was not the reason that I was asking the court to meet with the doctor, if the court will afford me a moment.
Okay, but we have been Mr. Scheib, when did you first bring all of this to our attention? Was it Monday, Tuesday? It was early this week, right? I mean, hadn't we been discussing this all week?
They retained me Monday morning. I was at the hospital, and then they called me what's more what you take, on and being in intensive care and all of that.
At least several days ago, you alerted everybody to this.
Judge, and that's why we had someone go to the hospital, and that's why we had someone speak to the doctor, and that is why we brought the representation that we did to the court. And the representation has been presented to the court regarding what Mr. Zachary is, or any impact what medicine he is taking would have on him and his ability to be harmed or to testify, and that was none. And Your Honor, frankly,
that was one person's version, was none.
Actually, we have the investigator who was in there with them, so if we can put that person up. But Your Honor,
at this point, we have no. I'm sorry. Go ahead.
No, Your Honor, you
go ahead.
Your Honor, there has been a series of events that we have put on the record. There has been no indication that Mr. Zachary is going to be unable to come in here and testify. He was released before we were even able to check on his status. Your Honor, he would not, and Grady has been apprised of what he is being released for. We know because we have had investigators down there. So the court may or may not have been privy or may have seen transcripts of other witnesses who lose all memory with the state, and it comes back when the defense starts asking questions. I don't know what kind of antics, as we have been apprised that Mr. Zachary doesn't want to testify, and his father wanted to or did call Mr. Sharp and Mr. Steele. I don't know what he's going to say, but Your Honor, I believe that he should not be allowed to hamstring, to hijack these proceedings by asserting things that are not.
Okay, so I think we have a fairly good indication through his attorney that he is potentially going to come out here and say some version of, I'm so messed up on whatever drugs they've given me that beats me. I mean, you're an elephant. So then how are you going to deal with that?
Your Honor, as Mr. Scheib did not relay that to me, and I don't
Well,
think
he
related
just
to,
relayed
no,
it to everybody in front of you. So
not
you
just-
heard it too. And it's been a possibility that he has relayed several times as well earlier this week.
Your Honor,
Yes?
the doctor is on the phone. How about that? That's what we have. We have the doctor on the phone. We can get the doctor on the phone.
I don't know
He's on the phone.
what his demeanor will be on the
We
stand.
have-
He has a great deal of anxiety, and that's one of the scenarios that he could go into a crisis with his
Anxiety, yes.
I think I've spoken to everybody. He's had this for 30 years and been built up, and quite frankly, he's an addict. He takes oxycontin every day, and can't take morphine because he's addicted, or he's. You just can't take that, but he's been on drugs for 30 years, and he's been in and out of intensive
Okay.
care.
Thank you.
We have the doctor on the phone, Your Honor. Could we,
Okay, yeah. Is everybody going to accept that this is his Grady doctor on the phone?
I think you need to have, what needs to happen is, under the law, he needs to give consent for her to have a conversation with him.
You have been having conversations with his doctor and the state for the last several days, so I assume that was with his consent. Am I wrong?
It is, but I don't know who
Okay.
it is, and for this man to give further information, he has to give consent.
So it's been a minute-by-minute consent that you have had with him for the state to communicate with his doctor about his condition, Mr. Scheib?
Judge,
Has
to
it?
be very clear, the other day when
Has it?
the other day, the doctor said, right now I can give you information as to what has happened.
I'm asking about the understanding that you have of Mr. Zachary's consent to let the state communicate with his doctor about his condition.
The other day. I don't know, he needs to come out and at least put it on the record, hey, I consent, we need to find out who the doctor is. I don't know who's on there.
That was my point, is I have no idea who's on the phone. That was my point. How about a Zoom call?
that's what we're trying to establish, Your Honor. We have his email address. The doctor's email address is.
Well, you don't need to put his email address on the record.
I'll
You don't need to put his email address on the record. I'm not emailing him.
I'm giving it to you. I don't need his email address. I need a name.
He gave oral consent a few days ago to a doctor that he knew. I don't know who this is.
What is the doctor's name to whom he gave consent to speak about his condition?
I think he needs to give consent to it.
You are his lawyer. What is the doctor's name to whom he gave oral consent to speak to the state about his medical condition?
I think they had the doctor on the phone. I think the doctor that I spoke to. That I personally spoke to, his last name is Marthambeagi. That's who I spoke to, face to face.
Okay. Thank you.
The person who's on the phone.
Huh? Okay. Well, until he is in person on, virtually in person on Zoom, that everybody can be a part of.
And I would ask my
Your Honor, could we
client
not
to
have
brought out,
this-
so he's privy to this.
Could we not have this
I think he's
televised?
entitled to it.
I need y'all to not talk at the same time. I cannot pay attention to both of you at the same time. Okay? Hey, Mr. Scheib, what are you asking?
That this doctor's conversation and communication not be televised.
Let me ask Mr. Scheib, because he's representing Mr. Zachary's interests with regard to this. And I do think that it would be appropriate, if requested, to not have this televised, because we're talking about somebody's personal medical information. Okay. Y'all need to not record this. So is the doctor joining us by Zoom?
Yes.
Okay. Thank you. All right. Ladies and gentlemen, we're going to jump to a different witness right now, and we'll circle back to the other witness later. Mr. Zachary, can you please stand and be sworn?
Quindarius Zach, Quindarrius Zachary, Zachary.
Good afternoon, Mr. Zachary. How are you? Mr. Zachary, hello.
I gotta speak back.
Yes, you're going to have to answer questions.
You said question, not speak back, but hey, how you doing?
Mr. Zachary, would you please tell the jury how old you are?
31.
All right. And where did you grow up?
Atlanta.
What part of Atlanta, Mr. Zachary?
Cleveland Avenue.
Where'd you go to school?
Cleveland Avenue Elementary.
And middle school?
Crawford Lawn.
Did you graduate?
No.
What was the highest grade you completed?
8th. 7-1 on.
Mr. Zachary, do you know any of the persons in the courtroom today?
Nah.
None of them?
Nope.
All right. Mr. Zachary, let me ask you this. Do you know Shannon Stillwell?
Yeah.
Do you not see him in the courtroom today?
I can't see. I just got to the hospital. You know that. I can't see that far.
All right. Do you need some glasses, Mr.?
If they got medicine in it, they don't work for me.
Mr. Zachary, were you present a moment ago when the court heard from your doctor?
Yeah.
And did you hear the doctor say anything?
You ain't asking what I know.
Sustained as to bolster.
I'm going to show you what has been marked as Case Exhibit 123 Echo. Do you recognize the person that has been depicted in State's Exhibit 123 Echo?
Yeah.
Who is this person?
Shannon.
And I'm going to play you what has been already admitted as 123 Echo. Mr. Zachary, while we're pulling that up, are you familiar with the person by the name of Jeffrey Williams, who also answers to the name Young Thug?
Yeah.
How long have you known him?
15 years.
15 years?
Yeah.
Do you consider him your friend?
Yeah.
All right. And the relationship with him that you have had, has it been good, bad, something in the middle?
It's all right.
All right. Now, when you say all right, does that mean you all have had no disagreements during the time that you've known him?
Everybody has disagreements.
I agree. Would you consider him a friend?
Yeah. All right.
All right. What does that mean for you?
Cool.
You're cool?
Yeah.
All right. Do you know a person by the name of Kelvin Watts?
Nah.
You've never heard of Kelvin Watts?
Nickname.
Shell Kel. Do you know a Shell Kel?
Yeah.
All right. How long have you known him?
I don't know him like that.
I didn't say how long.
I don't know him like that.
How long have you known of Shell Kel?
Like 2015.
All right. Are you cool with Shell Kel?
No.
All right. Now you chuckled. Why did you chuckle? Yes.
Cool.
Exhibit displayed on the screen. Are we going to use that exhibit or just?
I'm
Okay.
going.
You actually said you were going to publish it
Yes.
as a, I don't know if it's what it is, a video?
It's
or-
a video that has
Okay.
already
Are
been.
you ready for that?
In a moment, Your Honor. I was just completing the questions that I asked.
Can you take it off until we're ready for it?
Why did you chuckle when you said Shell, when I asked you about Shell Kel?
I just chuckle. What's the problem?
No, Mr. Zachary.
Okay then.
So you said you're not cool with Shell Kel. Is that what you said?
I don't know him to be cool with him.
Okay. What about Kenneth Copeland? Do you know of a person named Kenneth Copeland?
Nickname.
Woody.
Yeah.
How long have you known Woody?
About 10, 12 years, something like that.
And are you cool with Woody?
He all right.
What does he all right mean?
He cool, he all right.
Okay. What about Diamante Kendrick, Yak Gotti? You know him?
Yeah, he all right.
All right. And is that the same he all right that you mentioned with Mr. Williams and Mr. Stillwell?
Yeah.
All right. Moon Toon or Antonio Sledge, is he all right too?
Moonton?
Yes.
Yeah, he all right.
Okay. How long have you known Moon Toon?
About 20-something years.
All right. Demekion Garlington. Do you know who that is?
Yeah.
All right. And how long have you known him?
20 years.
All right. And what is your relationship with him? Is he all right?
He all right.
You cool? Okay. Now, do you have people, friends that you consider more cool or I than others?
Nah.
No?
Really. Not really.
Okay. So are you equally eyed with Jeffrey Williams, Shannon Stillwell, Diamante Kendrick, Demetrius, and Antonio Sledge?
Yeah.
Do you know Kelvin Treadwell or O.G. Bentley?
He dead, ain't he?
I don't know, Mr. Zachary.
His name Bentley?
Yes.
Yeah, I think something happened to him. I don't know.
You don't know whether you know him? Do you know a Demise McMullen?
No.
Do you know a Nard?
Picture.
I'm asking you first. Do you know a Nard?
Yeah, I know a couple of them.
All right. Now, the couple of them that you know, where do you know them from?
Prison.
All right. So if I show you a photograph, that I will mark 503 Yankee, can you tell the jury whether this picture that I'm holding in front of you depicts Nard?
I don't know. It's
Did
blurry.
you write anything on it?
Look like my name, but I don't know.
Is that your handwriting?
No.
That's not your handwriting?
No.
Okay. Do you remember seeing this picture before?
2015, I can't remember that.
Okay. But you remember knowing Mr. Stillwell in 2015?
You just showed me a clear picture of him.
I understand. You remember knowing him in 2015.
You showed me a clear picture of him.
Can you answer the question?
You showed me a clear picture of him.
So you remember part of 2015?
No, you showed me a clear picture of him.
Mr. Zachary, please answer the question.
I didn't answer the question. You showed me a clear picture of him. That picture just showed me one clear.
All right, Mr. Zachary, listen, she's not asking you now about the picture. She's asking you about something different. So listen to what she's asking and try to answer.
Yeah, I remember 2015.
You do remember 2015?
Yeah.
All right. Okay, so now we're going to go ahead and play the video that we previously had up on the screen that the court asked us to take down.
That same shit that got Big and Tupac killed, little fuck, nigga. Pussy ass, nigga, get your bitch ass killed.
for life.
Yeah. Hey, gang, you bring your pussy out here, you gonna see me. I'm at your fucking neck. Fuck anybody.
Mr. Zachary, did you see yourself in that video?
Yes,
And where were you seated in that video?
in the back.
All right, and were you behind Mr. Stillwell?
Yeah.
All right, did you hear what you said?
What I said?
Did you hear what you said?
No.
All right, can we play that again?
That same shit that got Big and Tupac killed, little fuck, nigga. Pussy ass, nigga, get your bitch ass killed.
for life.
Yeah. Hey, gang, you bring your pussy out here, you gonna see me. I'm at your fucking neck. Fuck anybody.
Did you hear what you said then?
Can't come too long.
Okay. Did you hear yourself say black?
No.
Did you hear anyone say black?
How you spell it?
Did you hear what I just said?
How you spell it?
Mr. Zachary,
No, I didn't hear nobody say black.
what did you hear being said that sounded like black, if anything?
Well, when y'all played this video on my trial, y'all say we said black, B-L-A-C-K. So that's what I'm gonna go with. That what
We're
y'all
not
said,
talking about anything but here today. Do you understand that, Mr. Zachary?
We said black,
What is that? How do you spell it?
B-L-A-C-K.
Okay, so now are you saying that what is being said is B-L-A-C-K?
That's what y'all told me it said.
Okay, Mr. Zachary, I don't want to know what anyone told you. I want to know what your understanding of what is
That's
being
my
said.
understanding, yes.
That is B-L-A-C-K.
Yes.
Okay. Have you ever heard B-L-A-T-T?
No.
Okay. Have you ever heard S-L-A-T-T?
I heard of, yeah.
Okay. Ever used it?
No,
Ever been around anybody that used it?
probably. I don't remember.
Do you remember how they used it if you heard them? No? Okay. I'm going to now show you, actually, could you tell the jury all the people that were displayed in that video you just saw? Do you need to see it again?
I just saw me and Shannon.
Okay, did you see it? You didn't see a third person in there?
I saw a third person, but I don't know who that is.
Do you remember when that video was taken?
2015.
All right. Do you remember where you were when it was taken?
In the car.
Where? What city?
Atlanta.
All right. And do you know what it is that you all were talking about?
Say something about game or something.
Mm-hmm.
Yeah.
What about game?
I just heard say game. Can't come to Atlanta, something like that.
Okay. And so did you hear yourself or anyone say YSL for life?
I heard it, but I don't know who said it.
Okay. Did you ask anyone on the video what that means, what you're talking about?
What do you mean?
I'm asking you if at any time in that car you said, what do you mean YSL for life?
No.
Okay.
I probably was high. I probably ain't paying attention that time.
Did you hear yourself talking?
Yeah.
Okay. Did you sound high to yourself?
What?
Did you sound high?
I'm saying the video, I probably was. We made the video.
All right, Mr. Zachary. I'm going to show you what has been marked as an admitted, and this is a screenshot, Your Honor, as State's Exhibit 441 Yankee. Do you recognize the people who are displayed in 441 Yankee, the screenshot?
Yes.
Who is that displayed in 441 Yankee?
Me and Mutton.
All right.
Little strip ass nigga. We ain't really going back to no nigga. You little bitch ass nigga. I know what we hate. I'm everywhere. Yeah, fuck you nigga, Cal. Whoever else, nigga. Well, nigga. Whoa. They said they ain't really going back.
Did you hear what was being said in the video?
Yes.
Now, who is the Kel that is being referred to? Go ahead.
They said, I don't remember.
Do you remember the Kel you told the jury you were not cool with a few minutes ago?
Yeah.
Is that the same Kel or a different?
Probably was.
Probably was.
Probably was him. I don't remember.
Do you remember making that video?
Yes.
When did you make it?
I like 2014, 2015, something like that.
Would it have been the latter part of 2014?
Yes.
And when you were holding the guns up to the camera, what were you meaning to show?
Shoot, gun. I showed a gun.
Why were you showing?
I don't know. Shoot, probably high.
Okay. Why were you saying the things you were saying to Caleb?
I said something to him.
Why was whatever you all were doing in that video being done?
I don't think I said nothing to him personally.
Why were you all shooting that video?
I don't know. I was just in the video.
With guns?
Yeah.
To the camera? How often do you do that?
A lot.
And do you do it at everybody or just Caleb?
Did I say something to him in that video?
Do you point guns at a video, in a video to everyone or just Caleb?
Probably everyone. Okay. Most of my pictures gonna be with gun.
Okay. When you say most of your pictures are with guns, are most of your pictures also with members of YSL?
No.
Okay. I'm going to show you what has been admitted as State's Exhibit 477 Yankee. I'm going to, nope. show you what has been marked, my apologies, as 4778. Would you take a look at 4778?
Yes, I see it.
All right. Can you see, without telling the jury out loud, the name at the top?
YSLD. Oh,
Okay. And can you see the caption at the bottom? Don't read it out loud at all.
yes,
Okay. Do you recognize this post?
yes.
All right. And how do you recognize this post? Where was it made?
Look like a club.
And where was this post placed on social media?
Look like Instagram.
Was it your Instagram account?
Yeah,
Is it a fair and accurate copy of the post on your Instagram account?
yes.
State tenders 4778.
It's admitted.
We're gonna permission to publish.
You may.
Thank you. And if Ms. Knight, you would blow up the bottom portion. Mr. Zachary, would you tell us what time and date is shown on that photograph, 4778?
I can see it.
If I put it before you here, can you see it right there?
7:02 p.m. February 26, 2015.
All right. And can you see, if I hold it here, what caption is under that post?
Yes, want me to say that out loud?
Now you can say that.
You remember all you niggas sleeping on us.
What else does it say?
YSL Thug on one.
All right. And if you would, Ms. Knight, bring the photograph down. Would you please tell the jury who is shown in this photograph from left to right as Ms. Knight puts the icon over each face? Who is that?
Mr. Williams.
All right. And what else do you call him?
Thug.
And who is that in the middle?
Munton.
All right. And who is that on the end?
Me.
All right. Now, is there an emoji after Thugger 1?
I can't see. You gotta show
You
me.
want to bring it up again? Can you see it on here? Ms. Knight, can you blow up the
Like
emoji?
like a bird.
It looks like a bird. Blow it up, Ms. Knight, all the way. That's as far as it'll go. Does it look like a snake at all?
No, I look like a little green rubbery ducky.
Do you typically use green rubbery duckies?
I use green anything.
What's special about green to you?
Cause I drink green lean.
Okay. Do you use other green emojis?
Hearts.
All right. And do you use red emoji?
Everybody use the red heart.
Do you, why didn't you answer the same way about everybody uses green hearts?
You said, why I use them? You ain't asked me about nobody else.
All right. So do you use red hearts?
Yes.
All right. Do you use any other emojis like that in your posts?
I use every emoji on the emoji app.
Now, the name YSL, how long have you had that as your Instagram handle, YSL Lil D?
Probably like 2015, 2014.
Okay. And do you know how long Mookton has had a handle YSL Toon?
I don't know.
When you first started using YSL Lil D, what did you mean for it to represent?
Shoot. What you mean? Like, what I meant for it, it meant?
What did it mean when you started using the name YSL Lil D?
I was hanging around. That's around the time I changed my name. I was going to show Mr. Williams stuff. That's when I changed my name The YSL for like the record label.
For the record label? What shows were you going to Mr. Williams?
A lot on.
A lot of them. Had you, before going to shows with Mr. Williams, had you gone to those type of shows before with anyone else?
Not well nobody performing though.
Okay. So are those shows that you remember because you hadn't done it before?
Yes.
All right. So what was the first show you went to with Mr. Williams?
I don't remember.
All right. Do you remember when it was? No? All right. So do you know a person by the name of Bug Buck or that calls himself YSL Buck?
Nah.
I'm going to ask you, have you ever made a post, I just bought some new guns and got rid of some friends you don't want to live my life? Under the name YSL Lil D.
I don't know. That's a fool. I don't know. I don't remember.
You said that's a what one?
A fool one?
What does that mean?
I don't remember.
What is a, did you say fool?
Yeah. Caption. Like, I probably would have said something like that.
Okay. What would it have meant if you had said something like that?
Exactly what he said.
Explain further.
Exactly what he said.
All right. And when you say exactly what it said, what does getting some new guns and getting rid of some friends have to do with that?
Shoot, I don't know. I probably heard it in the song.
What song?
I said I probably heard it in the song.
Okay. Now, do you remember when you got your first gun?
Probably like 14.
I'm going to show you what's been marked as 504 Yankee. State's Exhibit 504 Yankee. Is that the post that you made? You got a yes or no out loud.
Yeah.
All right. Do you remember when you made it?
I don't even remember that picture.
But do you remember the post?
It's on my page.
Okay. Is it a fair and accurate copy of the post on your page?
Yeah.
All right. State tenders 504 Yankee.
Admitted.
Thank you. Mr. Zachary, have you ever heard of of a group called 30D?
Yeah.
All right. Now, what is 30D?
A group from Canterville.
What kind of group?
I don't down know.
Do you know who I was a part of that group?
No.
Was the Mickey and Garlington a part of that group?
She probably will.
I'm going to show you what has been marked as 476 Yankee. Do you recognize the photograph shown in 476 Yankee?
Yeah.
Do you recognize whose page is posted on?
Yeah.
Whose page is it posted on?
Mine.
Is it a fair and accurate copy of the posting on your page?
Yeah.
State tenders 476 Yankee.
Admitted.
On 476 Yankee, could you read at the bottom the time and date that it was made?
10:04 p.m. May the 6th, 2015.
All right.
Got locked up that day.
What now?
No.
You said you got locked up that day?
Yeah.
What'd you get locked up for?
A gun.
Where was that gun?
What you mean? What was it?
Where was the gun?
It was on me.
Where on you?
In the car.
Who were you in the car with?
I don't remember.
Were you in the car with your girlfriend?
Yeah, I think so.
And her initials SG.
Yeah.
All right. How long had you made it SG at that time?
I don't remember.
What kind of gun did you have?
I don't even remember. I just know I had a gun.
Do you know how many guns you bought over the years?
don't know.
Where were you when you got locked up?
On Cleveland.
Do you remember where on Cleveland?
At the BP.
All right. Is it the BP at 151 Cleveland Avenue?
I don't know the address.
Do you remember at some point asking or meeting Detective Gaither after you got arrested?
No.
Do you remember ever talking to or meeting a Detective Dennis?
Yes.
Do you know who Detective Gaither is?
Yes.
How do you know who Detective Gaither is? Have you met her before?
The Mickey and Garlis and auntie were fucking her. I mean, excuse me, Judge. But they had a relationship.
So, were you ever present during any of what you just described? And Your Honor, actually, I asked that that be struck from the record.
You say how I know?
Have you ever witnessed any of that?
Yeah, he told
You
me.
were in the room?
He told me.
Okay, Your Honor, I'd ask that this hearsay be stricken from the record.
It's stricken.
Thank you. Do you have some kind of, are you saying you haven't had any interaction with Detective Gates?
You say how did I first hear about her?
You said you didn't know her.
You say how did I first hear about her?
Did you know her?
Not before then, no.
Okay. Have you ever sat in an interview room with her?
Yes.
All right. And have you sat in an interview room with Detective Dennis?
Yes.
Have you sat in an interview room with Detective Dennis and Detective Gates?
Yes.
Do you know how many times you sat in a room with Detective Dennis and Detective Gates?
Not that many.
Was it after you got arrested with that gun on Cleveland Avenue?
No, it was not.
Was it before?
No, it was way after.
Oh, okay, so it was way after. Okay. Was it in 2015?
Yes.
Was it in August of 2015?
Yes.
Did you ask to speak with Detective Gaither and or Detective Dennis?
No. What the hell? I'm gonna call 911 so you speak to the police?
Were you incarcerated in August of 2015?
Yes.
Were you in jail when you asked or when you spoke with them?
I ain't asked to speak with nobody.
Were you in jail when you spoke with them?
Yes.
Did you speak with them in an interview room?
Yes.
Was it, to your knowledge, in a room where you were being recorded?
Probably so, yes.
Okay. And did you talk with them?
Yes.
I'm going to show you what has been marked as State's Exhibit 471 Yankee, but not admitted. Do you recognize what has been shown and marked as 471 Yankee?
Yes.
How do you recognize it?
It's on my page.
All right, is it a fair and accurate copy of what's on your page?
Yes.
State tenders 471 Yankee, is that it?
Admitted.
May I publish?
You may.
All right. Who is shown in 471 Yankee?
Me and the Mickey
All right. And what's that in Demikion's hand, in his right hand?
a gun.
What's that in your right hand?
A gun.
All right. And what do you have at the bottom? Can you read the caption? Bring it up.
They can forward us if they want. We bring the homicide.
Who'd you tag?
30 D.
All right. It's 30 D Demikion Garland.
Yes.
All right. Who is the they you were talking about?
That's a song. That Lil Wayne.
Okay. So when you did that and pointed the gun at the camera, what was the reason you did that?
That's a song. I just told you on the last thing it probably was a song.
Okay. What was the name of that song?
For whatever you want, we bring the homicide. Word to my mama told her to get and not the game is like coming out of a
What's
coma.
the name of the song?
That's right. I don't know the name. That Lil Wayne song though.
Okay. And so when you pointed that at the camera, you didn't mean for it to display anything. You just wanted to put the song up there.
Most of my pictures gonna be with songs.
Okay. In 2015, January 2015, specifically January 10th, 2015, do you recall where you were?
In the house.
Now, when you say in the house, what house?
My mama house.
All right. How do you remember that?
Cuz, what you mean? I know I was in the house. Cause I was sick.
Okay. So, did you stay in the house all day?
Yes.
Do you remember anything else happening on January 10th, 2015?
No.
Do you know who Donovan Thomas is?
Yes.
Do you know when he was killed?
2015 sometime.
Do you remember it being January 10th, 2015?
It probably was.
Do you remember when you heard about Donovan Thomas being killed?
Probably the same day.
Do you remember how you heard about it?
I think somebody called me.
Do you remember where you were when they called?
I was at home. I just told you that.
Do you remember who it was that called you?
Probably months on.
I'm showing you what has been admitted as State's Exhibit 482 Yankee. You recognize the post in 482 Yankee for the picture.
Yes.
All right. And who is depicted in that picture?
Me, Shannon, and Yet.
Okay. And what date was that post made?
March 8th, 2015.
All right. And whose page was it made on?
OG, almost go boo.
Who is that?
I don't know.
Now, is this a fair and accurate depiction of the way you, Shannon, and Yak looked in this photograph at the time it was taken?
I guess. Oh, what you mean?
Is this a fair and accurate copy of the
Yeah.
picture? All right. State tenders 482 Yankee.
Submitted without objection.
Do you remember what time it was when you learned Donovan Thomas had been killed?
Probably around the time you got killed.
And what time do you remember that being?
I don't remember.
And you still don't remember who it was that called you?
I told you probably months on.
You said probably, not it was Lieutenant.
Probably, probably. I don't. Probably.
What happened after you got the call?
I went back to sleep.
For how long?
Rest of the night.
Did you go anywhere after that?
No.
What did you do the next day?
I don't remember the next day. I think we went somewhere, went out of town or something.
And who is we?
worried about Carter. They were worried about her drug use, her use of
Ladies and gentlemen, you've been here for 5 days now. Over 5 days, we've heard about
All right, please be seated. All right, the court's been informed that the jury's reached a verdict. I say this in every case. One half of this room, I don't know which half, is going to be upset. Do not add injury to insult. These people did not ask for this job. They didn't want the job. The state and the defense forced them into the job. You will not approve the jury's verdict, and you will not disapprove of the jury's verdict, or you will go to jail. It is a 30-day jail sentence for every outburst. I'm going to give anyone who does not believe that they are able to control their emotions the opportunity to leave the courtroom at this time. Would anybody like to leave? All right, Mr. Bailiff, please bring in the jury. You can sit right there, ma'am. Ma'am, I see you're holding some papers. The jury been able to reach a verdict in any of these counts.
Yes, sir.
All right, if you would, please hand the paper to the bailiff. Ms. Gregg, please rise and come to the podium, along with your attorneys. All right, the verdicts appear to be in proper form. Verdict of the jury is count one. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count two. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count three. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is to simply point at you and you answer out loud. As to count one, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry. Yes. On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count two, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Beginning on the first row. Ma'am, is that your verdict? Yes, sir. Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Yes. Ma'am, is that your verdict? Yes. On the back row, sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Yes. Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Count three, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Yes. Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Yes, ma'am, is that your verdict? Yes, on the back row, sir, is that your verdict? Yes, ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? All right, all three verdicts appear to be unanimous. The court will enroll the verdict. All right. All right, ladies and gentlemen, with you having returned a verdict of guilty in count 1 and count 2 of the indictment, we'll now proceed to the sentencing phase of the trial. State of Mississippi may call its first witness.
Your Honor, the state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard, with the exception of we seek to introduce one photograph.
All right. State wishes to move to adopt and incorporate by reference the record of the guilt phase. Is that correct?
That's correct.
Show your piece of evidence to the other side. Any objection?
Yes, Your Honor.
Y'all approach. All right, the state has moved to adopt and incorporate by reference the record of the guilt phase of the trial. The court will grant that request. Does the state have any other witnesses that wish to call?
No, Your Honor.
All right, defense may call any witnesses.
We don't have any witnesses, Your Honor.
All right. With the defense not calling any witnesses, attorneys approach. Does the defense rest its case in chief as to sentencing?
We do.
Do you also move to adopt and incorporate by reference to the record?
We do.
All right. Y'all approach. All right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further instruct you at this time. You, the jury, have found the defendant guilty of the crime of first-degree murder in count 1. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family, home, and environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for first-degree murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, your verdict will be as follows. Quote, count 1. Quote, as to count 1, we, the jury, sentence the defendant, Carly Mass and Gregg, to life imprisonment. Close quotes. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, Your verdict will read as follows, quote, as to count one, we, the jury, sentence the defendant, Carly Madison Gregg, to life imprisonment with the possibility of parole, close quote. If you cannot agree to the sentence for the defendant as to first-degree murder, your verdict will be as follows, quote, as to count one, we, the jury, are unable to affix the punishment, close quote. You, the jury, have found the defendant guilty of the crime of attempted murder in count two. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family and home environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for attempted murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, quote, as to count 2, we, the jury, sentence the defendant, Carly Madison Gregg, to life imprisonment, close quote. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows, quote, as to count 2, we, the jury, sentence the defendant, Carly Madison Gregg, to life imprisonment with the possibility of parole, close quote. If you cannot agree to the sentence for the defendant as to attempted murder, your verdict will read as follows, quote, as to count 2, we, the jury, are unable to affix the punishment, close quotes. All right. First closing by the state as to sentencing. Mr. Bailiff, 7.5 minutes. You wish a 2-minute warning or a 1-minute warning?
1 minute is fine.
1 minute. You may proceed.
Ladies and gentlemen, you've been here for 5 days now. Over 5 days, we've heard about this terrible crime that was committed by Carly Gregg. You have to consider her chronological age. We can't change that. She's 15 years old. In the eyes of the law, we talked about this on Monday, Carly Gregg is an adult. You do get to consider her age, but that's not the only factor you consider when you determine whether or not to send her to prison for life. We'd ask that she be sent to prison for life without the possibility of parole, and let me tell you why. When you consider her family and home environment, ladies and gentlemen, by all accounts, the defendant has told you she had a loving home. She had parents that adored her. She had every opportunity, more opportunities than most kids. She was advanced in school. She had guitar lessons. They took her to equestrian therapy. They took her to counseling. She had the opportunity to have medication. Nothing was enough for her. She still committed these heinous crimes. Nothing. Her home life was a perfect home life. When we talk about these factors in Miller, that usually comes up when we talk about these defendants that have been grown up on the streets, when their parents weren't present. Now, did Carly have a dad that she didn't love or had problems? Absolutely. But ladies and gentlemen, that is not enough. That is not enough for her to be able to walk the streets. She murdered someone. She attempted to murder her stepdad. Her family life and her dad being on drugs is not enough. The circumstances of the homicide, I don't have to tell you that. Y'all just lived it. You watched it. You saw those awful photographs. You had to watch that terrible video. We listened to Ashley Smiley's last sounds. We heard from Heath Smiley on that 911 call, the desperation. He said, help me. Help me. Ladies and gentlemen, those crimes were awful. She has shown zero remorse. Zero remorse for what she has done. Let's talk about her ability for rehabilitation. The defendant's own expert during the guilt phase of this trial said, you know, she's on this medicine, she's fine. But if you believed that, ladies and gentlemen, you would have believed that she was having some disassociated spell at the time of the crime, and that she's continuing to have these disassociated spells, and obviously no one's buying that, right? We don't know why she committed these crimes, but we know she did. And we know that she is a danger to society. If she is given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there 1 year or 10 years. We have no control over that. Ladies and gentlemen, we watched one of the most heinous things that I believe most of you will ever see in your life. Please do not let this lady have the possibility of parole. If she were paroled, nothing would stop her from walking into a school. Nothing would stop her from walking into a shopping mall. Nothing would stop her from walking into the grocery stores. Nothing would stop her from being in the movie theaters. Ladies and gentlemen, she is dangerous. She may look like a little girl. They may have said she's sweet little Carly, but unfortunately, we all know that that's not true. We will ask, and I will ask you again when we stand back before you, that you sentence Ms. Gregg to life in prison without the possibility of parole for both the murder of her mother, Ashley Smiley, and the attempted murder of her stepfather, Heath Smiley. Thank you.
Arguments as to sentencing by the defense. How much of a warning would you like, Mr. Camp?
2 minutes, Your Honor.
2 minutes. 15 minutes total.
Thank you, Your Honor.
Yes, sir.
I'm going to have to tell you, this is probably the most difficult thing I've ever had to do. I respect your jurors, and I respect your verdict, and I totally understand that. And now I'm in front of you. I know Gregg, when this happened, he was 14. She's 15 now. Her family's sitting on the front row. Her grandparents, which are Ashley's mother and father, have been supportive during this whole process. He's smiling. He's the victim in this case. He has been supportive. This is a family that's been torn apart because of this. This is extremely difficult on all them. And I know the state is up here saying that she's this heinous individual. And you've heard a lot of testimony that that's not who Carly is. You heard the counselors, Ms. Kirk. She couldn't believe it happened. Nobody knows why it happened. You have the opportunity to not make this worse on the family. You have 3 options. You can do life without parole, you can do life with parole, or you can let the judge make the determination. In this case, we would ask you to let the judge make the determination. We don't want you to give her a sentence for life in prison. Life in prison is life in prison. That's it. 14-year-old. She can come out of this at some point. And you were hearing she can walk out of here in 10. We don't, first of all, we don't know. And usually it's a lot longer than that. I mean, a lot longer. So, I don't want you to, go back in that room and think, oh, if you come back and say she gets parole, it's not a short sentence at all. We would ask you to allow the judge to make the sentence, because the judge understands. I'm not saying y'all don't. I mean, you don't have the ability, so don't get me wrong on that. But he knows, and the court knows, what we're actually looking at with times. And so please, in this situation, please let the judge make the sentence in this case.
Final closing on behalf of the state.
Ladies and gentlemen, Mr. Kemp is right. We may never know the reason why Carly killed her mom and attempted to kill her stepdad. And for me, that's even scarier than knowing why. Because if we don't know why, what's to say it won't happen again? We don't know. It is terrible for the family. The family has my sympathies, absolutely. I cannot imagine what any of them have gone through. We talked in Board Hour about how sometimes the victims cooperate with the prosecutor and the prosecution, and sometimes they don't. We don't always know why. But I know this. My office represents the citizens of Rankin County, and my office is asking you to please sentence Ms. Gregg to life in prison without the possibility of parole. Thank you.
Ladies and gentlemen of the jury, you've received you've heard the arguments. I'm going to ask you, I'll send you back the instructions. I'm going to ask that you retire to begin your deliberations. Everyone remain seated while the jury exits. Mr. Bailiff, they still have the verdicts, the evidence.
Yes, sir.
All right, if you would take those to them. All right, we'll be in recess till such time as the jury reaches its verdict regarding sentencing. Direct the bailiffs to inform me if the jury has a question. Jury's question is, what is life in prison without parole? Question mark, ears wise. Attorneys can approach. Look at the note. All right. Anybody need to review any further?
No.
All right. We'll mark this C next in number for ID purposes only. All right. Well, the truth of the matter is that the truthful answer to that question is nobody knows. However, typically, all the court can say is something to the effect of, you have received all of the evidence and instructions in this case. Please continue your deliberations. I'll hear arguments from the state as to response.
No argument, Your
By the defense.
Honor. No argument, Your Honor.
All right, I'm going to ask Ms. Butler or Ms. Eaton to write that out. Y'all know my handwriting's bad. I'm going to ask counsel for both sides to approach one more time. Look at the note. Make sure you agree that's what it says. Any objections by the state?
No, sir.
By the defense?
No, Your Honor.
All right. I'm going to ask Ms. Butler to make a copy of that. I'll mark the copy C next in number for ID purposes only. The bailiff will take the original back to the jurors. I'll take a copy. The copy of the note will be marked C next in number, C4 for ID purposes only. Mr. Bailiff, you can take that note to the jury. We'll be in recess till the jury reaches a verdict.
Already admitted as 123 Echo. Mr. Zachary, while we are pulling that up, are you familiar with the person by the name of Jeffrey Williams, who also answers to the name Young Thug?
Yeah.
How long have you known him?
15 years.
15 years?
Yeah.
Do you consider him your friend?
Yeah, all right.
All right. And the relationship with him that you have had, has it been good, bad, something in the middle?
It's all right.
All right. Now, when you say all right, does that mean you all have had no disagreements during the time that you've known him?
Everybody has disagreements.
I agree. Would you consider him a friend?
Yeah, all right.
All right. What does that mean for you?
Cool.
You're cool?
Yeah.
All right. Do you know a person by the name of Kelvin Watts?
Nah.
You've never heard of Kelvin Watts?
Nickname.
Shell Kel. Do you know a Shell Kel?
Yeah.
All right. How long have you known him?
I don't know him like that.
I didn't say how long.
I
how you
don't know him like that.
How long have you known of Shell Kell?
Like 2015.
All right. Are you cool with Shell Kell?
No.
All right. Now you chuckled. Why did you chuckle? Yes.
Cool.
Exhibit displayed on the screen. Are we going to use that exhibit or just?
I'm
Okay.
going to,
You actually said you were going to publish it
Yes.
as a, I don't know if it's what it is, a video?
it's
or-
a video that has
Okay.
already
Are you
been
ready for that?
It in a moment, Your Honor. I was just completing the questions that I asked.
Can you take it off until we're ready for it? Sorry.
Why did you chuckle when you said Shell when I asked you about Shell Kell?
I just chuckle. What's the problem?
No, Mr. Zachary.
Okay, then.
So you said you're not cool with Shell Kell. Is that what you said?
I don't know him to be cool with him.
Okay. What about Kenneth Copeland? Do you know of a person named Kenneth Copeland?
Nickname?
Woody.
Yeah.
How long have you known Woody? And are you cool with Woody?
He all right.
What does he all right mean?
He cool, he all right.
Okay. What about Diamante Kendrick, Yak Gotti? You know him?
Yeah, he all right.
All right. And is that the same he all right that you mentioned with Mr. Williams and Mr. Stillwell?
Yeah.
All right. Moontoon or Antonio Sledge, is he all right too?
Moontoon?
Yes.
Yeah, he all right.
Okay. How long have you known Moontoon?
About 20-something years.
All right. Demekion Garlington. Do you know who that is?
Yeah.
All right. And how long have you known him?
20 years.
All right. And what is your relationship with him? Is he all right?
He all right.
You cool? Okay. Now, do you have people, friends that you consider more cool or I than others?
Nah.
No?
Really. Not really.
Okay. So are you equally all right with Jeffrey Williams, Shannon Stillwell, Diamante Kendrick, Demekion Garlington, and Antonio Sledge?
Yeah.
Do you know Kelvin Treadwell or O.G. Bentley?
He dead, ain't
I don't know, Mr. Zachary.
His name Bentley?
Yes.
Yeah, I think something happened to him. I don't know.
You don't know whether you know him? Do you know a Demise McMullen?
No.
Do you know a Nard?
Picture?
I'm asking you first. Do you know a Nard?
Yeah, I know a couple of them.
All right. Now, the couple of them that you know, where do you know them from?
Prison.
All right. So if I show you a photograph, that I will mark 503 Yankee, can you tell the jury whether this picture that I'm holding in front of you depicts Nard?
I don't know. It's
Did
blurry.
did you write anything on it?
Look like my name, but I don't know.
Is that your handwriting?
No.
That's not your handwriting?
No.
Okay. Do you remember seeing this picture before?
2015, I can't remember that.
Okay. But you remember knowing Mr. Stillwell in 2015?
You just showed me a clear picture of him.
I understand. You remember knowing him in 2015.
You showed me a clear picture of him.
Can you answer the question?
You showed me a clear picture of him.
So you remember part of 2015?
No, you showed me a clear picture of him.
Mr. Zachary, please answer the question.
I just answered the question. You showed me a clear picture of him. That picture just showed me one clear.
All right, Mr. Zachary, listen, she's not asking you now about the picture. She's asking you about something different. So listen to what she's asking and try to answer.
Yeah, I remember 2015.
You do remember 2015?
Yeah.
All right. Okay, so now we're going to go ahead and play the video that we previously had up on the screen that the court asked us to take down.
That same shit that got Biggie and Tupac killed, little fuck, nigga. Pussy ass, you gonna get your bitch ass killed. For life. Yeah, hey, gang, you bring your pussy ass down here, you gonna see me. I'm at your fucking neck. Fuck anybody.
Mr. Zachary, did you see yourself in that video?
Yes.
And where were you seated in that video?
In the back.
All right, and were you behind Mr. Stillwell?
Yeah.
All right, did you hear what you said?
What I said?
Did you hear what you said?
No.
All right, can we play that again?
That same shit that got Biggie and Tupac killed, little fuck, nigga. Pussy ass, you gonna get your bitch ass killed. For life. Yeah, hey, gang, you bring your pussy ass down here, you gonna see me. I'm at your fucking neck. Fuck anybody.
Did you hear what you said then?
Can't come to Atlanta.
Okay. Did you hear yourself say black?
No.
Did you hear anyone say black?
How you spell it?
Did you hear what I just said?
How you spell it?
Mr. Zachary.
No, I didn't hear nobody say black.
What did you hear being said that sounded like black, if anything?
Well, when y'all played the video on my trial, y'all say we said black, B-L-A-C-K. So that's what I'm gonna go with. That what
We're
y'all
not
said.
talking about anything but here today. Do you understand that, Mr. Zachary?
We said black.
What is that? How do you spell it?
B-L-A-C-K.
Okay, so now are you saying that what is being said is B-L-A-C-K?
That's what y'all told me it said.
Okay, Mr. Zachary, I don't want to know what anyone told you. I want to know what your understanding of what is
That's
being
my
said.
understanding, yes.
That is B-L-A-C-K.
Yes.
Okay. Have you ever heard B-L-A-T-T?
No.
Okay. Have you ever heard S-L-A-T-T?
I heard of, yeah.
Okay. Ever used it?
No.
Ever been around anybody that used it?
Probably. I don't remember.
Do you remember how they used it if you heard them? No? Okay. I'm going to now show you, actually, could you tell the jury all the people that were displayed in that video you just saw? Do you need to see it again?
I just saw me and Shannon.
Okay, did you see it? You didn't see a third person in there?
I saw a third person, but I don't know who that is.
Do you remember when that video was taken?
2015.
All right. Do you remember where you were when it was taken?
In the car.
Where? What city?
Atlanta.
All right. And do you know what it is that you all were talking about?
It's something about game or something.
Mm-hmm.
Yeah.
What about game?
I just heard it say game. Can't come to Atlanta, something like that.
Okay. And so did you hear yourself or anyone say YSL for life?
I heard it, but I don't know who said it.
Okay. Did you ask anyone on the video what that means, what you're talking about?
What do you mean?
I'm asking you if at any time in that car you said, what do you mean YSL for life?
No.
Okay.
I probably was high. I probably ain't paying attention that time.
Did you hear yourself talking?
Yeah.
Okay. Did you sound high to yourself?
What?
Did you sound high?
I'm saying the video I probably will. We made the video.
All right, Mr. Zachary. I'm going to show you what has been marked as an admitted, and this is a screenshot, Your Honor, as State's Exhibit 441 Yankee. Do you recognize the people who are displayed in 441 Yankee, the screenshot.
Yes.
Who is that displayed in 441 Yankee?
Me Moonson.
All right.
Little strip ass nigga. We ain't really going back to real nigga. You little bitch ass nigga. I know where we hit. I'm everywhere. Yeah, fuck you nigga, Cal. Whoever else, nigga. Well, nigga. Nigga. Whoa. They said they ain't really going back.
Did you hear what was being said in the video?
Yes.
Now, who is the Cal that is being referred to? Go ahead.
He said, oh, I don't remember.
Do you remember the Cal you told the jury you were not cool with a few minutes ago?
Yeah.
Is that the same Cal or a different?
Probably was.
Probably was.
Probably was him. I don't remember.
Do you remember making that video?
Yes.
When did you make it?
I like 2014, 2014, 2015, something like that.
Would it have been the latter part of 2014?
Yes.
And when you were holding the guns up to the camera, what were you meaning to show?
Shoot, gun. I showed it them.
Why were you showing?
I don't know. Shoot, probably high.
Okay. Why were you saying the things you were saying to Kale?
I said something to him.
Why was whatever you all were doing on that video being done?
I don't think I said nothing to him personally.
Why were you all shooting that video?
I don't know. I was just in the video.
With guns?
Yeah.
To the camera? How often do you do that?
A lot.
And do you do it at everybody or just Kale?
Did I say something to him in that video?
Do you point guns at a video, in a video to everyone or just Kale?
Probably everyone. Most of my pictures gonna be with guns.
Okay. When you say most of your pictures are with guns, are most of your pictures also with members of YSL?
No.
Okay. I'm going to show you what has been admitted as Exhibit 477 Yankee. I'm going to, no. I'm going to show you what has been marked, my apologies, as 477 Yankee. Would you take a look at 477 Yankee?
Yes, I see it.
All right. Can you see, without telling the jury out loud, the name at the top?
YSLD. Oh.
Okay. And can you see the caption at the bottom? Don't read it out loud at all.
Yes.
Okay. Do you recognize this post?
Yes.
All right. And how do you recognize this post? Where was it made?
I look like a club.
And where was this post placed on social media?
Look like Instagram.
Was it your Instagram account?
Yeah.
Is it a fair and accurate copy of the post on your Instagram account?
Yes.
State tenders 477 Yankee.
It's admitted.
Permission to publish?
You may.
Thank you. And if Ms. Knight, you would blow up the bottom portion. Mr. Zachary, would you tell us what time and date is shown on that photograph, 477 Yankee?
I can see it.
If I put it before you here, can you see it right there?
7:02 p.m. February 26, 2015.
All right. And can you see if I hold it here, what caption is under that post?
Yes, want me to say that out loud?
Now you can say that.
Remember all you niggas sleeping on us.
What else does it say?
Why I said thug on one.
All right. And if you would, Miss Knight, bring the photograph down. Would you please tell the jury who is shown in this photograph from left to right as Ms. Knight puts the icon over each face? Who is that?
Mr. Williams.
All right. And what else do you call him?
Thug.
And who is that in the middle?
Munton.
All right. And who is that on the end?
Me.
All right. Now, is there an emoji after Thugger 1?
I can't see. You gotta show
You
me.
want to bring it up again? Can you see it on here? Ms. Knight, can you blow up the emoji?
Like a bird.
It looks like a bird.
Oh.
Blow it up, Ms. Knight, all the way. That's as far as it'll go. Does it look like a snake at all?
No, I look like a little green rubbery ducky.
Do you typically use green rubbery duckies?
I use green anything.
What's special about green to you?
Cause I drink green lean.
Okay. Do you use other green emojis?
Hearts.
All right. And do you use red emoji?
Shoot, everybody use the red heart.
Do you, why didn't you answer the same way about everybody uses green hearts?
You said, why I use them? You ain't asked me about nobody else.
All right. So do you use red hearts?
Yes.
All right. Do you use any other emojis like that in your post?
You every emoji on the emoji app.
Now, the name YSL, how long have you had that as your Instagram handle? YSL Lil D.
I like 2015, 2014.
Okay. And do you know how long Moonton has had a handle YSL Toon?
I don't know.
When you first started using YSL Lil D, what did you mean for it to represent?
Shoot. What you mean? Like, what I meant for it, meant?
What did it mean when you started using the name YSL Lil D?
I was hanging around. That's around the time I changed my name. I was going to show Mr. Williams stuff. That's when I changed my name to YSL for like the record label.
For the record label? What shows were you going to Mr. Williams?
A lot on.
A lot of them. Had you, before going to shows with Mr. Williams, had you gone to those type of shows before with anyone else?
I was like performing, though.
Okay. So are those shows that you remember because you hadn't done it before?
Yes.
All right. So what was the first show you went to with Mr. Williams?
I don't remember.
All right. Do you remember when it was? No? All right. So do you know a person by the name of Bug Buck or that calls himself YSL Bug?
Nah.
I'm going to ask you, have you ever made a post, I just bought some new guns and got rid of some friends, you don't want to live my life? Under the name YSL Lil D.
I don't know. That's a fool. I don't know. I don't remember.
You said that's a what one?
A fool one?
What does that mean?
I don't remember.
What is a, did you say
Yeah. Caption. Like, I probably would have said something like that.
Okay. What would it have meant if you had said something like that?
Exactly what he said.
Explain further.
Exactly what he said.
All right. And when you say exactly what it said, what does getting some new guns and getting rid of some friends have to do with one another?
Shoot, I don't know. I probably heard it in the song.
What song?
I said I probably heard it in the song.
Okay. Now, do you remember when you got your first gun?
Like 14.
I'm going to show you what's been marked as 504 Yankee. State's Exhibit 504 Yankee. Is that the post that you made? You got to say yes or no out loud.
Yeah.
All right. Do you remember when you made it?
I don't even remember that picture.
But you remember the post?
It's on my page.
Okay. Is it a fair and accurate copy of the post on your page?
Yeah.
All right. State tenders 504 Yankee.
Admitted.
Thank you. Mr. Zachary, have you ever heard of of a group called 30D?
Yeah.
All right. Now, what is 30D?
A group from Canterville.
What kind of group?
I don't down know.
Do you know who I was a part of that group?
No.
Was Demikian Darlington a part of that group?
She probably will.
I'm going to show you what has been marked as 476 Yankee. Do you recognize the photograph shown in 476 Yankee?
Yeah.
Do you recognize whose page is posted on?
Yeah.
Whose page is it posted on?
Mine.
Is it a fair and accurate copy of the posting on your page?
Yeah.
State tenders 476 Yankee.
Admitted.
On 476 Yankee, could you read at the bottom the time and date that it was made?
10:04 p.m. May the 6th, 2015.
All right.
Got locked up that day.
What now?
No.
You said you got locked up that day?
Yeah.
What did you get locked up for?
A gun.
Where was that gun?
What you mean? What was it?
Where was the
It was
gun?
on me.
Where on you?
In the car.
Who were you in the car with?
I don't remember.
Were you in the car with your girlfriend?
Yeah, I think so.
And were her initials SG?
Yeah.
All right. How long had you dated SG at that time?
I don't remember.
What kind of gun did you have?
I don't even remember. I just know I had a gun.
Do you know how many guns you bought over the years?
I don't know.
Where were you when you got locked up?
On Cleveland.
Do you remember where on Cleveland?
At the BP.
All right. Is it the BP at 151 Cleveland Avenue?
I don't know the address.
Do you remember at some point asking or meeting Detective Gaither after you got arrested at that BP?
No.
Do you remember ever talking to or meeting a Detective Dennis?
Yes.
Do you know who Detective Gaither is?
Yes.
How do you know who Detective Gaither is? Have you met her before?
Demikian Garlington auntie was fucking her. I mean, excuse me, Judge. But they had a relationship.
So, were you ever present during any of what you just described? And Your Honor, actually, I asked that that be struck from the record.
You say how I know?
Have you ever witnessed any of that?
Yeah, he told
You
me.
were in the room?
He told me.
Okay, Your Honor, I'd ask that this hearsay be stricken from the record.
It's stricken.
Thank you. Do you have some kind of, are you saying you haven't had any interaction with Detective Gates?
You say how did I first hear about her?
You said you didn't know her.
You said, how did I first hear about her?
Did you know her?
Not before then, no.
Okay. Have you ever sat in an interview room with her?
Yes.
All right. And have you sat in an interview room with Detective Dennis?
Yes.
Have you sat in an interview room with Detective Dennis and Detective Dennis?
Yes.
Do you know how many times you sat in a room with Detective Dennis and Detective Dennis?
Not that many.
Was it after you got arrested with that gun on Cleveland Avenue?
No, it was not.
Was it before?
No, it was way after.
Oh, okay, so it was way after. Okay. Was it in 2015?
Yes.
Was it in August of 2015?
Yes.
Did you ask to speak with Detective Gator and or Detective Dennis?
No. What the hell? Call 911 so let me speak to the police?
Were you incarcerated in August of 2015?
Yes.
Were you in jail when you asked or when you spoke with them?
I ain't asked to speak with nobody.
Were you in jail when you spoke with them?
Yes.
Did you speak with them in an interview room?
Yes.
Was it, to your knowledge, in a room where you were being recorded?
Probably so, yes.
Okay. And did you talk with them?
Yes.
I'm going to show you what has been marked as Exhibit 471 Yankee, but not admitted. Do you recognize what has been shown and marked as 471 Yankee?
Yes.
How do you recognize it?
It's on my page.
All right. Is it a fair and accurate copy of what's on your page?
Yes.
State tenders 471 Yankee. Is that
Admitted.
may I publish?
You may.
All right. Who is shown in 471 Yankee?
Me and the Mickey on.
All right. And what's that in the Mikion's hand, in his right hand?
A gun.
What's that in your right hand?
A gun.
All right. And what do you have at the bottom? Can you read the caption? Bring it up.
They can forward those if they want. We bring the homicide.
Who'd you tag?
30 D.
All right. Is 30 D Demikion Garland?
Yes.
All right. Who is the they you were talking about?
That's a song. That Lil Wayne.
Okay. So when you did that and pointed the gun at the camera, what was the reason you did that?
That's a song. I just told you on the last thing it probably was a song.
Okay. What was the name of that song?
For whatever they want, we bring the homicide. Word to my mama, told her to get it out the game. It's like coming out of a
What's
coma.
the name of the song?
That's right. I don't know the name. That Lil Wayne song though.
Okay. And so when you pointed that at the camera, you didn't mean for it to display anything. You just wanted to put the song up there.
Most of my pictures gonna be with songs.
Okay. In 2015, January 2015, specifically January 10th, 2015, do you recall where you were?
In the house.
Now, when you say in the house, what house?
My mama house.
All right. How do you remember that?
Cause, what you mean? I know I was in the house. Cause I was sick.
Okay. So, did you stay in the house all day?
Yes.
Do you remember anything else happening on January 10th, 2015?
No.
Do you know who Donovan Thomas is?
Yes.
Do you know when he was killed?
2015 sometime.
Do you remember it being January 10th, 2015?
It probably was.
Do you remember when you heard about Donovan Thomas being killed?
Probably the same day.
Do you remember how you heard about it?
I think somebody called me.
Do you remember where you were when they called?
I was at home. I just told you that.
Do you remember who it was that called?
Probably Moon.
I'm showing you what has been admitted as State's Exhibit 482 Yankee. You recognize the post in 482 Yankee for the picture.
Yes.
All right. And who is depicted in that picture?
Me, Shannon, and Yet.
Okay. And what date was that post made?
March 8th, 2015.
And whose page was it made on?
OG_Bull.
Who is that?
I don't know.
Now, is this a fair and accurate depiction of the way you, Shannon, and Yak looked in this photograph at the time it was taken?
I guess. Oh, what you mean?
Is this a fair and accurate copy of the
Yeah.
picture? All right. State attendance 482 game.
Submitted without objection.
Do you remember what?
Like, Miss Williams.
Okay. And how did you help out with the clothes and stuff?
Send the clothes.
And what kind of clothes would you sell?
Stoner t-shirt, stuff like that.
Did you ever sell free Roscoe gear?
You know, I was locked up and Roscoe got locked up. I don't sell the t-shirt.
Okay. But do you know about free Roscoe gear?
No.
Other than stoner gear, have you ever sold any other kind of gear?
I think some, I don't remember. I just know whatever t-shirt they had.
Do you ever sell anything with slime on it?
No.
Have you ever used slime in the context of this record label?
No.
Have you ever used slime in any other context?
Have I used it?
Yes, you.
Probably so.
And how are you using it?
I don't remember.
Have you ever heard Shannon use it?
No.
Have you ever heard Thug use it?
I think in the song, yeah.
Have you ever heard Yak use it?
Probably in the song.
Have you ever heard Nard use it?
Who is Nud?
Demise and Mother.
You gotta show me a picture. I told you that.
Do you know a person by the name of Justin Cobb who also answers to the name Dubois?
You gotta show me a picture.
Is that a no or yes?
You gotta show me a picture. I told you that.
Okay, so right now you don't know until you
Right
see
now, I
the
don't know until I see a
picture.
picture.
Okay. After you got arrested with that gun on Cleveland Avenue, and let me ask you this: do you remember buying the gun at a pawn shop?
Yes.
Do you remember which pawn shop?
Yes.
Which one?
Arrowhead.
All right. How many guns did you buy at Arrowhead pawn shop?
About 3.
All right. Were they all the same kind?
No.
All right, what were they? What kinds were they?
I don't know.
Were they long guns or handguns?
I think both.
All right. How many long guns did you buy?
2.
All right. Now, the gun in the video with you and Moulton talking about Kale. Did you see that?
Yes.
All right. Was that one of the guns you bought?
No.
Now, was the gun in that video similar to one of the guns you bought?
No.
All right. Did you give one of your guns or sell one of your guns to Kenny Copeland?
Let him borrow a gun, yes.
Okay. When did you let him borrow your gun?
I think I was out of town and he just ended up keeping it.
Do you remember around the time it was?
2015?
Do you remember around what month?
No.
When you spoke with Detectives Gaither and Dennis, was it always at the same place?
What you mean always at the same place?
Was it always at the same place, at the Atlanta Police
I
Headquarters?
only spoke with him probably 1 or 2 times. I ain't no always at no same place. No.
Those 1 or 2 times, was it at the same place?
I think so.
Did you ever speak with them, either Detective Gaither or Detective Dennis, individually outside of that place?
No.
And did you ever individually reach out to either one of them outside of that place?
No.
When you said that you traveled with Shannon Thug, possibly Yak,
I think Mr. Williams already there. And somebody in Florida, he was already there.
he was already there?
Yeah.
Okay. Well, when did you go in relation to January 10th?
I don't know. It was the next morning. Yeah.
And when did Mr. Williams go?
I don't know. I just know he was already there.
So was he there on January 10th?
I just told you he was already there when I got there.
I'm asking
We
you,
got
was
there
he
late
there
on that
January
night, the
10th?
next night.
Was he there on January 10th?
I don't know.
When you say we, so did you, Shannon, and Yak travel together?
Yes.
How did y'all get there?
I think a Sprinter or something like that.
Who purchased the Sprinter?
I don't damn know. I mean, I don't know.
Did you purchase it?
No.
Was that the first time you was ridden in a Sprinter with Shannon or Yak?
No.
How often have you ridden in a Sprinter with Shannon and Yak?
I don't know.
When you rode in the other Sprinters with Shannon and Yak, where were you going?
I don't remember. Probably sure.
Okay. And so who paid for those Sprinters?
I don't know. I don't know.
Did you know where Mr. Williams lived during January of 2015?
Yeah.
How many residents did he have?
One that I knew of.
Where was it?
Downtown.
What was it called?
Ain't Sky House.
What kind of place was it? An apartment, a condo, a standalone house, or something else?
Condo.
All right. Do you remember what floor he lived on?
No. Yeah, I think.
Which one?
Or the limb or something like that.
Okay. Do you know who else? If anyone lived with him?
Lived with him?
Yes. Lived with Mr. Williams?
I don't know.
All right. How often did you visit Sky House?
A lot.
When did you first start visiting Sky House?
Probably when you first got it. I don't
Which
know.
was when?
I don't know.
Was it in 2014?
Yes.
Was it early part of 2014?
I don't remember.
When you say you went a lot, would that mean more or less than 5 times a week?
Probably more.
Would it mean more or less than 10 times a week?
Nah, I ain't went no 10 times a week.
So between 5 and 10 times a week you visit?
Yeah.
Now, when you went, how did you get there? Did you drive? Did you walk? How did you get there?
I drove.
What kind of car did you drive?
I don't know.
Did you have your own car on January 10th?
I always had my own car.
What kind of car did you have during that time?
I don't remember.
How many cars have you had?
I don't remember.
Did you ever drive any of Thug's cars?
I think a van, Sprinter van or something before.
A Sprinter van?
Yeah.
As to count 2, we, the jury, sentence the defendant, Carl Madison Gregg, to life imprisonment. On the front row, ma'am, is that your verdict? Yes, sir. Ma'am, is that your verdict? Sir, is that your verdict? Yes, sir. Ma'am, is that your verdict? Ma'am, is that your verdict? On the back row, ma'am, is that your verdict? Yes, sir. Ma'am, is that your verdict?
The screen. The jury who you are saying today was in the car with you. Said you shot up somebody's house.
He said I did.
Okay. Garling, the one that you've been friends with for 20 years?
Yeah.
All right. Did he tell you why he would say that?
I ain't asked him. I just laughed.
Oh, you did? Okay. Okay. So if you believe that Garlington told them that you did it, why did you deny doing it initially?
Because you're supposed to deny it.
Okay. Did you tell detectives Gaither and Dennis what you believed that Garlington had told them?
Yes, I put a mixer to it though.
A what?
I twisted it up a little.
What do you mean?
Shit, I added on what I wanted to add on.
What does that mean?
Try to make myself look innocent.
Okay, fair enough. So who else did you believe that Garlington had told shot up these people's houses?
What you mean?
Your Honor, that calls for hearsay.
I said, you can, I'll rephrase.
Okay.
Who else did you tell detectives Gaither and Dennis shot up these homes on April 28th, 2015?
I don't remember. Like 10, 9.
Did you tell them that Moontoon shot up the houses?
No. I told him Moontoon would die. I never told him Moontoon shot no house.
Okay. Did you believe that Garlington had already said something about Moontoon?
Yes.
Overruled.
All right. And you, Moontoon, and Garlington were all equally close to one another during this time?
No.
Okay. Then describe if you all weren't
Me and
equally.
Moontoon closer.
You and Moontoon were closer? Okay. And so when you believed that Garlington said Moontoon did something, how did you confront him about it?
Front who, Garlington?
Yes.
No.
Okay. Now, if Garlington said that you and Moontoon shot up these houses, along with Garlington, was Garlington conveying something that actually had occurred?
Can't use a word I understand.
Which part didn't you understand?
Conveying.
Okay, thank you. Was he saying something that had actually happened?
Yes.
Okay. So then you just went in and told Gaither and Dennis what happened because you believed or knew that Garlington had already done it?
I knew, yes, I knew.
Okay. Now, did you ever tell Moulton that Garlington had told on him?
I think he knew already.
I'm asking you if you ever told Moulton that Garlington told on him.
No, I was just trying to like free Moulton.
Okay. Were you? Okay. Did you also tell Gaither and Dennis, or rather, let me ask you this. When you did you try to tell them at first that you were not there?
Probably did. I don't remember. I think I did probably.
Do you remember whether they told you you were there? I have your phone records.
And then I think I told them that.
But yes or no, just that part first, okay? You can explain, I promise. Just, do you remember whether Gaither or Dennis told you, we know you were there because we got your phone records?
I think they did say that.
Okay. Now, did you want to say something else after that?
Yes, but when the phone came back, it went in my name, so they didn't have my phone name. And I already knew that.
Okay, what do you mean when the phone came back, it wasn't in your name?
When they tried to see whose name the phone was in.
Did they tell you they tried to see whose name the phone was in?
Huh?
Did they tell you that they tried to see whose name the phone was in?
I think my lawyer had already knew.
What?
Somebody told me.
Did they tell you before that interview?
Yes, when I got locked up for the May the 6th, when I got caught with a gun, I think they had said in the open court.
Okay. Did you think that the phone being in someone else's name would make it harder for the police to find out it was you who had done the shooting?
They didn't find out because of the phone.
I understand, but you mentioned they found out it was in someone else's name, right?
Yes.
So did you think that would make it harder for them to learn it was you?
Yes.
Okay. Whose name was the phone in?
I don't remember. I just know it went in mine.
Okay. You know what?
No, it wasn't in my name.
All right. I don't want to know your mother's whole name. I just want to know what it begins with.
Okay.
Okay. And that phone that you had at that time, is it one that you still have now?
No.
All right. So is it okay to ask you about the whole number?
No, you can't.
Why?
Because that's my mama number.
Okay. So it's still your mom's number?
Yes, it was never my phone.
Okay. Give me the last digit of your mama's number.
3.
All right. How long has your mom had that number?
About 20 years.
All right. And if I show you the first 6 numbers without publishing them of your mom's number, will you recognize it?
Yes.
All right. Your Honor, I will, for purposes of this questioning, label this exhibit States 505 Yankee. And if anyone wants to see it, I will show it to them. Okay. approaching, with the court's permission,
You may.
approaching you with state 505 Yankee, okay? That's this. I don't want you to call out any of these numbers. Were those the first 6 digits of your mom's number?
Yes, y'all thought that was my number?
Let me ask you this.
Yes,
Were
sir,
those-
yes. Yes.
Okay. And is this the number that you believe that they had the records?
No.
So your mother's number that she's had for 20 years, now you're saying that's not the number that they had the records to?
No, that's not the number.
Okay. So whose number did they have the records to?
I told you a cell phone that belonged to me, but was in somebody else's name.
So it was your cell phone?
Not that phone right there.
I understand. But the cell phone they had the number to was your cell phone?
Yes.
And you no longer have that cell phone?
No.
Does your mother have that cell phone?
She got the number you just showed me.
I understand. Does your mother have the cell phone that belonged to you but that was in someone else's name?
What the number is? You show me the number.
You said your mother had one number, and this was it, right?
Can you show me the number so I can make sure?
I can.
That number right there, yes, that's her number.
Did she have any other? Is this the one she had for 20 years?
She got 2 phones.
Oh, she got 2 phones.
Yeah.
The second phone, what number does it end in?
I don't remember. It ain't on no more.
So nobody uses that number. Is that the number that you had that was in someone else's name?
No.
So let's stop talking about your mama's phones, okay? All right. So who had the phone? Whose name was the phone in that you had?
John Doe.
John Doe. Okay. So now, since nobody owns that number now, may I ask you the full number?
Yes.
All right. Did that number end in 5726?
Yes.
Okay. Thank you. Now, if the number was in the name John Doe, and the police had that number, do you have any personal knowledge of how they learned or found out you were the one using that phone?
No.
All right. And I'm going to show you what I have marked as State's Exhibit 506, Yankees. And if anyone wants to see it, I'll let them see it. All right. I'm showing you 506 Yankee, and I'm asking you, is that the number that you had that was in the other?
Yes.
Okay, thank you. And the number is at the top line of 506 Yankee? Is on the top line?
Yes.
All right. Were you, Demikion, and Moton the only people you told detectives Gaither and Dennis were in the car with you?
I don't remember.
Do you remember telling them Shannon was in the car with you too?
If I did, I lied.
Okay, but do you remember telling them that?
Yes.
What good would it have done, or did it do you to tell them Shannon was in the car with you?
Because Garlison told him Moulton was in the car.
So what does that have to do with Shannon?
That's his homeboy.
If Garlington told them Moulton was in the car, and you told them Moulton was in the car, why did you?
I told him Moulton was in the car after I tried to free Moulton.
It's your testimony that you said that Moulton was in the car only after you told them Shannon was in the car?
No, I had already knew. I was a steps ahead of y'all already.
Okay, so I'm sorry. I'm slow. Would you tell the jury, are you saying that you told the police?
I told the police that Shannon was in the car because I was mad because Garlison said Moonton was in the car.
Okay. And did you tell the police that Montuk was in the car before you told them Shannon was in the car?
How I supposed to know? 10 years ago. I don't remember.
You remember why you told them, you said.
Yes, but how I know what I said first?
Did you give them any details about what happened?
I think I told them what house we went to, yeah.
And did you tell them who it was that you were looking for at the house?
I don't remember if I did. You had to show me or something. I don't remember.
Okay. Do you remember telling Detectives Gaither and Dennis that you graduated
I ain't
from
no,
high school?
I ain't never say no nothing like that, man.
Okay. I'm asking you if you did or not. Do you remember giving them your mother's number?
When? In court, probably, yes.
No, in August, and thank you for making me clarify. In the August 2015 interview with Detective Gaither and Dennis, that you told the jury about her.
I ain't getting my mama number.
Okay. Do you remember giving them her name?
Yeah, I probably gave my name.
Okay. Do you remember them reading you your rights?
Yes.
Do you remember waiving your rights?
Yes.
And at the time that you spoke to them, had anybody forced you or threatened you to go down and make a statement?
No, my whole plan was to just go free Moonton.
Did they ask you whether you could read and write English?
I don't know.
And did they tell you or ask you, what is the big rush? Why did you want us to come down and talk to you?
And what I say?
You gotta answer.
I don't know.
I'm gonna pause y'all for a minute. There's a juror that's feeling sick. Might be a couple of minutes. So let's pause. I don't quite know how long it's going to be, so no, he doesn't need to.